With the Lordship's permission, may I mention item 23 today's list?
Kindly wait for your turn.
May I mention item number 7 listed?
Wait. Oh,
Tomorrow before. I mention item number 7 listed tomorrow before.
Yes, what do you want?
No, I'm seeking for a 2 weeks adjournment.
Make a mention tomorrow, don't make it in advance. Yes.
Item 1.
Mediation.
Item 1
still going on. Yes.
Honorable Justice Purinjo's
Yes,
report is there.
8 weeks I was requesting on his behalf.
One minute. Mediation है on Justice Purinjo's report अभी आई नहीं. Mediation is
Still awaited. It's going on.
is in progress.
It's
Yes,
in
progress.
It's in progress.
And counsel for the party jointly pray for an adjournment. We listed on कोई May में date दे दीजिएगा.
July, Lordship may have it in July, because the parties are in America actually. That's why the problem in coordinating.
Family dispute, what is there in it? You request the learned mediator to please expedite it. May में date दे दीजिएगा. हाँ? Monday, Tuesday, Friday, कुछ Tuesday. Hopefully, for the next date, the report of the learned mediator would be on record.
Please, my lords. Item 2, the matter has been settled before mediation, my lords, before the Honorable High Court. And my lords, in view of the settlement, my lords may pass orders under 142 also.
I'm appealing for the vice members who have received the
Petitions, sir.
Application.
1 minute.
When can you file a joint application? Parties are on connected today?
No, my lords. Then
Or then they have to be. Parties have to be.
Parties have to be here.
fix a date, I'll ask them to appear online.
Monday?
My lords, they need to come all the way from the south.
No, digitally.
Online.
See,
Complaint.
today is Tuesday.
Please,
By Friday, you file the application under 142.
please,
And you will keep it for Tuesday.
please.
And parties can join digitally. Council would verify that.
Affidavits have to come from Chennai. The affidavits have to come from down south.
So it can come within a day. What is there in it?
We'll ask them.
Please.
Please.
Next week, my lords, I request for a week.
142. The parties shall file joint application under Article 142 before the next date. Parties can join digital.
Item 3.
Through digital mode. Yes, please.
At the time of his death, he was barely 21, my lord. His father had predeceased him, 2 sisters, my lord, 1 brother, 1 mother. He was the sole breadwinner of the family, my lord.
Who's for the other side?
And for the assemblies. Because in this case,
Ms. Bagga, he claims 5,800, but the courts below have taken 3,800. High Court has taken
yeah, that is as per minimum wages.
minimum wages. So,
Yes.
gentlemen, how do we increase it from above minimum wages? Because there's
Lord, because
salary certificate is there.
he fights, my lord, appointment later, PW file.
We have seen that. Ms. Bagga,
Please, my lord.
can we increase it to 5,800? You are very fair counsel, because the salary certificate is there, his employment certificate is there, letter is there.
I leave it to your lordships.
In
Otherwise,
totality.
this is as per pronacity.
Sorry?
Otherwise, the calculation is as per pronacity, as well as.
No, correct. We are only thing.
Okay, I leave it to your lordship. Whatever your lordship may direct.
Instead of 3,800, we'll make it 5,800. Interest,
Interest 9%, my lord, grant.
6%.
Lord,
Interest would be 6%.
my lord, he granted.
Sorry, interest will be 6%.
Labor code granted 9%, my lord. Reduced.
Then we are very clear. If the, have you received the amount in the
No,
High Court?
I have no instruction regarding this.
No.
We
He will
possibly
say,
deposited.
he will say on the enhanced amount. On the enhanced amount, in today's date, monthly income from 5,000 to 3,800 to 5,800, and interest on the enhanced amount at the rate of 6%.
Would your lordship consider around 9%?
Thank you, gentlemen. Don't be so greedy, please.
I leave it to your lordship.
From the date of the petition to the date of discussion.
Keep your measurements.
Thank you, Mr. Gai.
Sometime,
Thank her, Mr. Counsel.
where the amount is to be deposited, no, some direction.
That we will, that the usual order is there, he will supply the particulars to you, you will, within 4 weeks, deposit you.
Please, no, oblige me.
Item 4.
Please, Your Lordship. Your Lordship, the petitioner is the owner of the house in dispute, Your Lordship, which is under the possession of the respondent from 2007 onwards without payment of any rent. The rent controller evicted the respondent, Your Lordship. Appeal filed by the respondent was dismissed, but the Honorable High Court.
Lordship, there is already a decree in my favor.
Decree?
Yeah, 2008, which is captured on page number 2, Your Lordship. The impugned order.
Decree or specific for how much?
Correct, Your Lordship. So the only thing is that I could not, the benefits of the decree could not be accrued to me because I failed to deposit the amount.
So the ownership will not transfer.
I understand, Your Lordship. But that does not entitle landlord and tenant relationship between
No, the finding of fact was returned by 2 courts below. The High Court was sitting in revision and it could have only seen whether there is any evidence to support the finding or not. There was oral evidence in respect of tenancy. Where is the discussion in respect of the oral evidence? Can revisional court exercise its power in the manner in which the High Court has done?
Lordship. But that
Just 2-paragraph order. And there is no written agreement.
absolutely
You
not.
don't need a written agreement for a tenancy agreement. Where is the law?
But there is no relationship between me and the.
The finding of the court below is that you entered into possession in June.
Correct, Lordship.
Agreement for sale was in October.
Correct, Lordship.
There is nothing in the agreement to indicate that transfer of possession took place while the agreement was executed.
But
So the landlord-tenant relationship is proved, as was held by the 2 courts below. Where is the question of setting it aside?
Lordship, that if you see, can you see page 2?
Answer these 2 questions. The finding is that you entered in possession in June.
Right.
The agreement for sale was entered in October.
Correct, Lordship.
The agreement of sale, there is no recital that you entered possession through that agreement.
Right.
So your agreement was oral.
Correct, Lordship.
So
But-
once that is the case,
Can
there
you
is the
see
question to set it aside.
Lordship, there is an agreement to sell actually. After that, without through the.
That way, you see, umbrella manufacturing, unless it materializes into a sale
Right.
and there is a merger complete, then only the tenancy comes to an end. There is no merger, there was no sale. The decree, you did not fulfill the condition of the decree. So where is the question of merger?
Lordship, if.
The tenancy terminates only when the limited right merges into the final and the whole right.
Correct, Lordship.
But where is the merger? There is no transfer of property.
But the possession was given to me, Lordship, and I make the payment.
Possession was given in June, that is what the finding is
Right.
by the courts below. That has not been set aside by the High Court. Right? High Court was exercising revisional powers.
Correct, Lordship.
That's to be allowed.
Lordship, if there is only question of balance payment which is remaining actually. That's why the agreement is.
Gentlemen,
That decree is over.
you understood what my lord is saying.
I have understood.
You
Lordship.
understood that.
Correct, Lordship.
And now there are 2 things. When will you hand over possession?
Lordship, if.
As a tenant, you will have to have a handover possession. If there is a decree in your favor, you have to take recourse to such provisions as are available in law.
Lordship, I don't have any sections that.
No, then we are.
हम लिखा दें.
Save it. Thank you.
Lordship,
Please.
Yes.
In detail, today's date.
It would be allowed in today's date.
Please, Lord. Highly obliged.
Lordship, the small solution can be.
Yes.
If it can be referred to mediation and if the balance amount if they agree, because ultimately they want to sell it off, Lordship. The only reason is that why they are.
You filed a suit, you did not comply with the condition, what can be done?
The reason is why they are retracted.
That decree has become final.
Correct, 2008 decree.
So it is not non-executable, what can be done? File a suit for refund or whatever it is, otherwise.
Lordship, but the predicament here is this is the 2018, the order was passed. They came in 2023, Lordship, before the honorable court.
Law will have to take its course, sorry, yes.
So there is an inordinate delay of 5 years, Lordship. The judgment is dated 2018 and they are approaching the honorable court in 2023. There is no explanation delay also.
No explanation? for
Yes,
the-
explanation. Only explanation offered.
Yes, what do you say about delay?
Your Lordship, actually, he was a poor person, Your Lordship, when no other way was left out, then he approached this honorable court with great difficulty because there was no other way left out for him. He is a poor person having this on.
You are challenging an order of 2018 and 2023.
Your Lordship, actually, he was not in possession of this.
एक मिनट कॉल दिखा ना. Has the delay been condoned?
No, Lordship, no.
And only number of years has also not been mentioned. The only reason they are getting is.
Just understand. Yes, sir. Application of delay will be noticed.
Okay.
What is your explanation? Just show your explanation.
Your Lordship, with regard to the delay, this is the only explanation that he, being a poor person, was unable to approach this honorable court at that time and was having not other any source of income. So with his merger income, Your Lordship, when he gathered the money, then he approached this honorable court. Because his only house with.
Did you file a reply to this application?
That is, Lordship, their reasoning given is in parallel.
Have you filed any response to what is being?
I filed my not to this application.
Not a case.
That is mentioned.
In the delay and allowance.
Item 5.
Please, Your Lordship.
Please, Your Lordship.
Mediation
Has failed, my lord.
Notice was issued limited to
only on mediation.
because the distance is negligible. It is from Ghaziabad to Kakaduma courts in Delhi, which is hardly 10-15 kilometers.
My lords, the restitution of conjugal rights petition was
Sir,
filed.
please kindly see 29th of January 24 order.
Yes,
Issue notice only for the purpose of exploring as to whether
yes, please.
mediation is failed.
Yes, please.
And Shadra and Karkaduma, Ghaziabad and Karkaduma,
The respondent himself operates a shop in Chandni Chowk,
what do we do now?
and this has come
Both of
through
us
Supreme
tried
Court
our
Legal
best.
Aid Services.
Since 6, there has been no efforts as such for mediation. There
You
are
want mediation?
take notes.
You want
We
mediation?
settle it out. I have spoken to
No instructions for mediation.
Then we can refer it to mediation. Take, if there are no instructions, we pass over, take the instruction. Just pass it.
please.
Item 7.
May I please? This is a transfer petition by Y Millard seeking transfer from Haryana, Gurgaon Millard, Gurgaon, Haryana to Jamshedpur, Jharkhand.
My lord, there's the one thing which is very important.
Yes.
This is a petition of 2021. They filed this transfer petition in 2024. After that, my lord, what is very important in this matter that after 4 years they are recording the evidence. She has not joined the any time in Haryana and Gurgaon. She is staying in Bangalore. Everything is filed is there, my lord. She need not to come. She will. My lord, to give her permission to join to the BC. My lord,
We give it to that court. We'll say it is open for you to appear. Make a request before the appropriate court for appearing.
Because my lord, my father and everybody is senior
We have
citizen.
only
80 years.
seen this, that we give it to that court. And great court.
My lord, keep your.
My lords, under the petitioner, we are seeking transfer of divorce petition, my lords, from Kakinada to Hyderabad.
No, what is, as per office report stands, correct.
So,
So-
none appears. None appears.
None. Pass it.
Item 9. And the respondent Millards.
Because I am appearing for the petitioner. The petitioner is seeking transfer from Shivpuri,
It's a
Madhya Pradesh.
criminal complaint.
Because it's a private complaint filed by my former husband. Because what happened is that they have got the marriage annulled in Shivpuri because he's an excise officer having substantial influence. I was arrested in a 498 case, made to suffer in jail for almost 3 days with my minor child and son.
In offense of 420 also, this court has charged you with 420.
Because the cognizance order was challenged, the cognizance order was upheld only with respect to petitioner number 1.
And you can travel to this court twice.
Milos,
Sorry.
Milos, may kindly consider
Sorry,
Milos. Milos, I have a minor child to take care of. In my custody, Milos.
Facts are very bad.
60 years old mother, Milos. Milos, at least,
Not this.
Milos may at least consider this, Milos. I may be allowed to attend through BC, Milos.
It is always open for you.
You apply to-
Milos may record it, Milos, because that would have
Always
substantial
Always
influence.
open for you.
Milos may consider these are 3 destitute women.
You are an accused. This court has charged you with 420.
Milos, I am ready to face the trial. Milos may at least record that I may attend to
Thank you.
through BC, Milos. Milos, at least through BC, Milos.
Thank you, sir. Thank you.
Very well.
Your Lordship, I'm seeking to pass over.
Pass over.
Item 11. Item 11. Because in item 6, I have obtained instructions
Yes, Your Lordship.
6.
for
Mediation.
mediation. My with VC might be a
First is received, then we leave it to the learned mediator. इसमें
much of it.
एक पैराग्राफ लिख लीजिएगा that वो मिस आउट कर रहे हैं, पता नहीं क्यों मैंने दिखाया था. The wife were to travel to Delhi, the husband would bear the expense for travel, lodging and boarding. मैंने दिखाया था sentence. अभी जो भेज रहे हैं उसमें मिस आउट हो रहा है. नहीं हमने और स्टैंडर्ड ऑर्डर है ना, हाँ वाइफ है, मीडिएशन को भेज रहे हैं, उसमें सब में आए.
First hearing through VC, Your Lordship.
First through VC, rest through mediator.
Much
So rest we leave it to the mediator.
Please, Your Lordship.
Much obliged.
Travel को जरूर किए. हर बार नहीं होना.
Lordship said item 11, Mr. Patwalia was appearing. I'll seek a pass over, but your Lordship said ask.
Lords, I am appearing for the respondent, Your Lordship. My
Lordship.
prayer is.
Had asked for a judgment. We placed that on record. It's completely in my favor actually. Because it,
Yes.
Lords, there are 2 judgments which I am also citing, Your Lordship.
Yeah, Mr.
Please, Your Lordship.
Yes, Mr. Suri, you want to say something?
Yes, Your
How
Lordship.
do you respond to this recent judgment of Honorable Justice Partiwala?
My Lords, I have not gone, but I have got 2 judgments, Your Lordship. My Lords, may give me a short date, I'll assist my Lords
we are
on
not
that
giving
also.
short date, we are
passing over, I'll send them a copy of it.
no. Reserve, give your written submission in 2 days.
Wait.
Clearly.
Please, Your Lordship. Please, Your Lordship.
Lordship, in item 12, respondent number 1, the state of, the standing counsel for the state of UP has a personal exigency. He's not in court today because his father has been hospitalized.
Just 1 minute. Why did we issue notice? Your sale has been held to be sham. Yes, Mr. Counsel.
We were under impression that state is taking a judgment.
Who's the original counsel? Ask him to come.
Mr. S.R. Singh, learned senior counsel, is appearing on behalf of the petitioner.
Okay, come on Tuesday.
In the meantime, we will comply with the filing of the spare copies for issuing notice on to the LRs of.
No, we are not inclined. We are telling you today. We'll have it on Friday.
In these matters, notices are being issued to LRs of R6 and 9 as spare copy and running file. No need.
अभी थोड़ा Friday को देखते हैं ना.
Item 13.
Lordship is seeking time to ascertain the status of the trial. We were told last time that the respondents.
Stage of trial. You are
for the state.
Now, what is the stage of trial? We'll pass over. We'll pass it over. Just find out. We'll pass it over. Just find out what is the stage of trial, because you see it is 2021 Liberty News.
Last year we were told they were absconding and they hadn't appeared. Last time we were certain.
Just now, call the learned. Just find out. Pass it. Stage of trial, whether they are cooperating or not. That's the only.
Item 14.
Well, Mr. Sanjay is in this matter. He's currently on his legs before another court.
This, I believe, is common transfer. Bench was held pending. There was a refusal.
We'll just pass it over.
Yes.
Just pass it over.
But it'll take some time.
We know we're ready to hear it, sir. There are 2-3 matters which need to be heard today.
Well, if I am on my legs, Rosh will accommodate you.
No problem. No problem.
Very well.
I don't know whether. Anyhow, it's an interesting question. We are ready to hear.
No problem.
खरीदा है बेचने वाले की
Item 15 that I appear for the respondent.
Standing counsel is on his legs with front of the board members.
One minute.
Make a request. Make a request
for that.
Let the trial court record this.
That order is that's standard order.
Item 16.
By 16, there are 2 connected appeals of the other accused. There are 3 accused in total. The 2 connected appeals, the lordship will get.
It has to be tagged along.
Yes.
Those have been admitted.
Yes. We have now spent almost 9 years. We have spent 9 years in jail. I just request for bail.
Lordship, I have objection on
Then
that.
We are not granting bail there. Just
what is this practice, Mullahs? I have not even opened my mouth. No. I'm only saying.
Because the custody certificate is not clear on how much he has undergone. He is saying 9 years.
Mr.
I'm only saying I only made a right.
We have umpteen number of times we have said that this interjection is not involuntary. But nonetheless, what do we do now? Admit, he granted, वो जो usual order होता है, record the court for so and so, then tag along with so.
May I just, because I've served 9 years, I'll practically, if he wants.
More applications.
The application is pending. My bail application is pending. I'm saying your lordship will grant me put only for bail on some date. Your lordship will give some date in April. I have no problem.
एक मिनट देना. Hearing expedited. This, when do you want it? This side or that side?
Whenever your lordship.
You tell us. We are ready anytime. This side or that side? Tell us.
This side. I am ready with the matter, so this side.
Why did we ask you, gentlemen?
Lordship.
This is the third time, fourth time. We didn't want to say. It is his matter.
Plus, all the evidence is not on record. So
All for the record.
The purple order that we supply to the then comes to the parents. Based on the part on July meeting.
Your lordship are difficulty. We are appearing for the Supreme Court Legal Services Committee.
Sorry.
I'm saying we are appearing for the Supreme Court Legal Service Committee. That's why I said I don't have the full records.
No, we are the usual order is leave granted. Trial court record be called for. List is directed to supply complete record in a digital form to the learned counsel for the party. That's the usual order.
Item 17.
May I please, your lordship? There is a time declaration.
There are, yes.
And both of system are valid in the same manner.
Malot's item 19.
19 years, Mr. Navneet Kumar.
Malot's, I am appealing for the respondent in item 19. Malot's.
Respondent number?
1, Malot's.
You are for the insurer, not correct. Now you
Malot's.
see in the additional documents they are placed on record the salary slip. Just see that. Page 13 of the
Malot's, the copy which is served to me, nothing can be figured out from. It's absolutely illegible, which has been provided to me, Malot's. And my lords will see the impugn order.
1 minute. There is an appointment letter working in a government recognized school on the post of TGT. That is with effect from 1st of October 2012. Additional.
My lords, this need to be checked whether this is part of the travel or not, because page number 5, 6 and 8 clearly the Honorable High Court has recorded that they have not challenged the 205 rupees per day. They only said 26 days wages has been taken, we want 30 days. My lords, may kindly have that. This is now creates a serious doubt about it.
An MA and a B.Ed qualified person would be having how much? 6,150 in the year 2000.
My lords, we are not on that right now. We are.
See, the High Court has quantified on the basis of minimum wages. That cannot be.
My lords, that's the difficulty. Every court, my lords, will see what has happened before High Court. High Court, the petitioner itself has gone and said, I am not disputing. Please give me 30 days.
That's not correct, Your Lordship. Your Lordship may see my petition.
May I just show one paragraph, then my lords, I'll get back to
Before
on
the
that.
Honorable High Court. Page 100, round C, before the Honorable High Court.
No, this letter was before the High Court.
This letter was before the learned tribunal. This letter was before the Honorable High Court.
It was there.
My learned friend
Mr.
is.
Navneet Kumar, are you in the court? Are you in the court complex only? Why don't
No,
you
my lords, I'm not in the court complex, my lords. I need to even check whether this was part of the record or not, but I want to show just one paragraph of High Court.
Learned counsel says that it was part of the court record.
Yeah, I'm
Lords, I'll try checking it.
It was a part of the court record.
Mr. Navneet, what do you say?
My lords, I need to get it checked, my lords, whether it was part or not, because the interim order.
We'll have it on Friday. Mr.
My lords,
Ravindra Singh Gadia.
Mr. Ravindra Singh
Gadia, G-A-R-I-E.
Gadia submits that appointment letter dated 1st of October 2012, page 13 of additional documents, was part of the trial court
record, and in fact,
the proceedings before the MACT, correct?
Yes, Your Lordship. Absolutely.
List on Friday.
My lords, in the meanwhile, can I, friend, serve me a legible copy? The original one which is placed with the MA is absolutely not legible.
Not legible because I have submitted typed copies and photocopies of original documents.
Do it again.
I will send a PDF again. Most obliged.
He need not say that. Do it again. He'll do it just now only. Well, you have your learned friend's telephone number.
My lords, we do have each other's numbers.
Then immediately send it on WhatsApp.
Most obliged.
Item 20.
Lordship, in this matter, we have filed additional documents.
Sorry?
We have filed some additional documents.
So that's all right. What is wrong with the order? Tell us.
Lordship, in this matter, I seek some small adjustment. Lordship, for
Why? Sorry. Sorry, we are not inclined.
Lordship, then I'm. Yes.
You argue, please. Yes. Please argue.
Lordship, in this matter, the petitioner remained unheard and one not granted any opportunity to bring the correct facts on the record. Particularly, Lordship.
Finally, come to page 8, sir. Page 8.
Lordship,
finally,
yes.
come to page 8.
Yes,
last but one paragraph. As such, under these circumstances, court is of the considered view that the issue involved in the present petition also stands squarely covered by the judgment of so and so. This aspect that the issue stands covered by the learned by a court judgment is not disputed by the standing counsel for the state.
Okay. Lordship, 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 may I request kindly see the additional documents, Lordship. In this case.
Sorry. Thank you, sir. Thank you.
Lordship, may I, only 1 minute. Lordship, 1 minute. Lordship, 1 minute. Lordship, in this matter, they have filed the contempt petition. That's what here. That's what. Lordship, but the Honorable High Court realized that there is just some defects. Lordship.
Thank you, sir. Thank you.
Item 21.
Okay.
My lords, in item 21.
Yes, please.
I'm for the state, Your Lordship. I'm seeking 2 weeks accommodation in the matter, Your Lordship.
Why you tell us this?
Your Lordship, there's a change in the council.
Change in the council?
Yes, Your Lordship.
There's a change in the bench also, but we are hearing it.
Just a week's accommodation if Your Lordship may grant.
Let us start, let us see. Start.
Lord, I am in the connected appeal, my lord.
That's all right.
21.1.
Correct, sir.
This is on behalf of the commission, my lord. I have filed an appeal. This pertains to the Electricity Act, my lord. The include order is dated 28/1/2020.
Correct, sir. Please just start. They won't start. Mr.
No, my lord. I can start my case, my lord. I am in the connected.
Start.
21.1, my lord.
Start.
Yes. Lordship, I have made some.
Read listed dates and submission.
Correct.
My Lord, I'm just handing it over. Yes, Your Honor. My Lord, there are challenges on the merits of the order and on the jurisdiction of the commission, my lord. Merits of the order, I am not filing an appeal, my lord, because I am a commission. I am only confining my appeal to certain directions given by actor, with which I am agreed, my lord. If your lordship may see the list of dates, just for the sake, my lord, what has happened is this is pertaining to, my lord, certain concessions given under the Tamil Nadu government policy, my lord, for wind generators, my lord. There are certain benefits which are given under the Electricity Act. In fact, much prior to the Electricity Act coming into force, the benefits were given for the wind power, my lord. These facilities were several facilities, my lord, which were given from 2003, prior to 2003. Now, my lord, the issue in this
is a statutory appeal.
Statutory appeal, under 121.
Right. Now, what is the scope of the appeal?
Yes, scope of the appeal is, my lord, the question of law, whether there has to be a substantial question.
Correct.
Yes.
Only a substantial.
Yes. Now, my lord, I will
say
say substantial question of law is, my lord, the jurisdiction, the power exercised by the honorable actor has gone beyond the scope of the very regulation framed by the commission, because my lordship very well knows the commission regulation framed by the commission is bound, my lord, all the authorities, the commission as well as the actors are bound. If at all anybody is agreed, the regulations have to be challenged. The regulation provides for variation, modification of the benefits, my lord, under the policy. Now, what the actor has done is, you cannot withdraw this benefit. It has to be done in perpetuity, my lord. That is the direction with which I am agreed. But I will show it to you, my lord, how it has happened. There are certain benefits which have been given from time to time. Yes. Now, the impugned order has said that you, whatever benefit you have given from 2003 or 8 onwards, you cannot withdraw by any means, because you have to extend in perpetuity, in spite of the factual position that today the wind power, my lord, is the maximum. The benefit has been, wind generators have got the maximum benefit in Tamil Nadu. We have given the, my lord, in the impugned order passed by the commission, my lord. We have given the breakup of what is the effect, my lord. I have to show all those things, my lord. But briefly, the question is whether the power exercised by the actor curtailing my power to even not to withdraw the benefit given, my lord, is it legally sustainable? There are other issues, my lord. This is a broad issue, my lord. The power under the, for that, my lord, I want to show the relevant provisions of the Electricity Act before I come to the factual position, my lord.
Point one is.
Lordship, I'm appealing for the appellant in this matter, Lordship, first matter item number 21. Lordship, there is a change in counsel, Lordship. I may be permitted to file my wakalat number. Kindly grant us 1 week time.
Close this, no? Close this.
What are the substantial questions of law which you are?
Yes,
this one.
Well, in so far, TNERC is concerned.
One minute.
Lord,
we'll call for you.
Lordship, I kindly have page 83 of the paper.
Oh, no, which paper?
The 21.1, my paper book. The appeal filed by the commission.
20.1.
21.1.
No, 20.1. Yes, we're not 20.1. This one. Which is the substantial question of law?
Yes, Lordship, my kindly.
In your opinion, Lordship, be frank, Lordship, paper books from the previous counsel. That is
adjourning the matter. Don't worry. Just we want to see what is the whether we pay or not is something we want to know. We want to find out. 20.1 the appeal.
That is appeal number 2882/84 of 2021. Lordship, may kindly have page 83.
83?
Yes. My lord, question B, my lord. So there are several questions, but I'll not disturb you, trouble you a lot with all the questions. Question B. Whether the directions of the Honorable Appellate were justified when the same was contrary to the regulation, namely the power procurement from new and renewable source of energy regulation 2008. Whether the direction of the Honorable Appellate goes against the basic object of setting of the Regulatory Commission and regulations shown by it under section 61 read with 181.
Just a minute. And in 21,
yes.
One minute.
Yes. 121 minute appeal.
We have seen that. In 21, we have just seen whether any question of law is taken or not. Mr. Kaushik, we need your.
Will we kindly have
1 minute. On which are the substantial questions of law in 21 which would arise from constitution?
Lord, in fact,
whether we agree or not is a totally different matter, but which are the questions that should. Mr. Patel, are you in this case? You are for the respondents or for the.
I am for the respondent.
85. There's a substantial question about presumably according to them arise. Now, Lord, in 21.1. In 21.1, first I'd just like to.
You are in. We are talking of 21 now.
21, but page 85.
Yes, see. So which one of them really arises?
According to me, these are more question of fact, my lord, which was not of law.
Electricity Act.
Nothing.
Electricity Act.
Lord, 121.
1 minute.
Section 121.
We'll do one thing. We will keep this case on Monday. All of you, please sit down and give us revised questions of law which arise for consideration.
Lord, kindly get 21.1 for 1 minute. 21.1 and 125 of the Electricity Act. 125 of the Electricity Act provides for appeal to Supreme Court.
Correct.
Now, my lord, it says any person aggrieved.
Correct.
Now, my lord, in 21.1, the appellant is TENRC.
Correct.
Now, the Regulatory Commission. But they are the Regulatory Commission. They can never be a person aggrieved.
So therefore, this itself is a question of law, whether they are agreed or not.
That has been decided by you.
No, my lord.
No, this issue we have decided
Gujarat Utility, my lord.
ERA's judgment. And we have held that they are a person aggrieved.
My lord.
That issue will not.
Way back in West Bengal, my lord, your lord.
So what we do is, we will keep this case for Monday. You may exchange the questions of law which arise for consideration.
Yes, please.
In both these appeals, they arise from the common judgment.
Common order, common order.
Common order. So give it to us, we will frame them and we will, on Tuesday onwards perhaps, we may hear it.
Please. Yes,
my lords, in fact, my lords had asked for written submissions to be filed. We have filed written submissions.
No, say, if we are to discuss these appeals, then only written submissions.
Very well.
Answer the questions.
Please.
Why should we not even, if we are to dismiss it, I answer the questions in the form.
Lord, as far as the friend's grievance is concerned, I'll satisfy my lord. I am a person aggrieved because I am on. That's why I said.
My God has said that this question in another matter has already been.
Yes, madam. It settled way back in 2002, but West Bengal case.
We are not saying anything. We are simply adjourning it for
Yes.
Monday.
I may be permitted to file my wakalat demand.
Certainly.
2 days.
You want more time? Monday?
No, 2 days. 2 days time.
Our attorney, 21 May, we filed for the next set of hearing. Then we request the learned counsel for the parties who prepare questions of law which would arise for consideration for in the present fields, so filed under section 125 of the Electricity Act 3. list on Monday.
Monday is a holiday, my lords, Tuesday.
Sorry, Tuesday.
My lords, appellants will have to make out a substantial question of law. Let them place it, my lords, and my lords may
And
consider.
Mr. Patel,
Please, my lords.
we will dismiss it in limine, no problem.
Very well, very well.
Why don't you please, all of you sit, put your heads, because after all, it's public money, public interest, and better that we solve the issue once and for all.
Very well, very well. We'll assist the court, my lords. We'll assist the court.
They want to knock it down as a 2020 match, my lord. It has to be a 5-day match, my lord. Argued at length.
No problem. We are in no rush.
Yes.
Only thing is we must understand what is to be adjudicated. That's what all. And if we have correctly got it, whether you can withdraw the benefits or not, incentives, that's the prime issue.
Yes. And your lordship have held, my lord. It's also covered, my lord. Your lordship have held.
Whether you have the power or you should both withdraw the incentives or not, that's the prime question.
Right. Of this. Grateful, my lords. Grateful to you.
Article 22, I beg to appeal the appellant in the state of Maharashtra in 20. Sorry.
Yes,
Let's in item 22, I beg to appeal for the state of Maharashtra, the appellate.
Sorry.
Let's in item 22, I beg to appeal for the petition of the state of.
Which case, sir?
So a batch of 88 matters in which about 10 or 12 matters service is not complete.
No, sir, service is not required. We'll tell you the reason.
May I just indicate the contours of the matter? No, I'm saying.
1 minute.
So this is concluded, my lord, by judgment of apex court in.
Just bear with us, sir. Just give us 1 minute. जब वो बाद में साहब के लिए कौन जरूरी ये कहना जरा 2020 का 11 दीजिएगा 2020 का 11 144
That's Chief Regional Officer versus Pradeep Phillips. You just pass on this to your official.
1 minute.
You have copies? I have copies. I'm carrying copies.
ये कुनील साहब की इज्जत
has attained finality, and if it has, then whether the benefit would be withdrawn of the debt. That is all.
It's the section 10 of the Act.
Just one. We are on the view that it has attained.
Look, so
They are all linemen, four class 4 employees.
Look, may I just explain how?
Yes. We will tell you the fact.
No, not the facts. But may I just explain the concern of the government?
What is the concern of the government?
The concern of the government is this: the unequivocal decision of your lordships in the FCI case minutes was to give complete effect to Section 10. Till that point of time, Section 10 of the Act was not given complete effect to. Your Lordship said in a 3-judge bench decision, that the natural consequence and the only consequence is to withdraw benefits that have accrued to the candidates because their caste certificates or tribe certificates have been found to be invalid, fraudulent, etc. That means, there is a clear overruling of all those decisions, and specifically so in the judgment, which said that they will be entitled to protection. So, in which case, the earlier view giving them the protection orders was because they thought that element of mens rea was required. These people have knowingly or unknowingly done it. Therefore, we will protect the judgment so far their benefits, the educational or job benefits that they have accrued to them under the fraudulent stroke invalid caste certificate. Your Lordship said that view is no longer good, no longer protection. Therefore, categorical that withdrawal of benefits is the only.
There are two things. Overruling would overrule the precedential value of earlier decisions. But what about the judgment being binding inter-party?
So far as the judgment is a different aspect. An answer to that. The impugned government circular of December 2019 does not deny them the benefits of a government job. What it does, it creates supernumerary posts. Otherwise, I'll tell you what happens.
The first judgment of the Bombay High Court, wherein they were directed to be given protection.
That's not on record. The protection orders are not on record in these matters. We'll file them, We'll file them. I'll tell you lots of our concern, just to indicate our concern. See, there are about thousands of people who are working under protection orders like this. You have now declared that they are not SD community. If they are not SD community, what then happens? Your Lordship, this is not a one-time affair. Once they get into the government service for the next 30 years, they occupy that quota. We are unable to fill these seats with genuine quota. So we are not saying that even we have not gone the whole way as the Supreme Court judgment says to throw them out of the hub.
One thing is that when the court said that they have not committed a fraud, error, be that as it may be for whatever reason, we will protect them. Honorable Justice Gawai, then he was there. He has passed that order.
Yeah.
One such order is passed back.
Yes.
Now, you did not lay any challenge to that order.
No, in fact,
1 minute. Now, these are all people who are either class 4 or class 3.
With all due respect, no. Some of them are.
Some are assistant teachers, some are clerks, some are linemen. That's about all. We have got a list of what they were doing, what they were elected as, on which post. Now, you did not, you allowed the controversy to be put at rest at that point in time. It is only because of the judgment in 2017 that you woke up. You protected their service. Not only you protected their service, you also said they'll be entitled to all the emoluments. And that's your circular. It is only, that's a circular. 1 minute now, just.
Right.
You not only protected them, but you also said this, that they'll be entitled for monetary benefits. However, neither they nor their progeny would be entitled for benefits under the certificate for any purpose whatsoever. You accepted that statement. And it is only after 7 years, because there was change in the position of law, the 3-judge bench said no, it will apply retrospectively. Then also, Honorable Justice Korean Joseph, in this judgment, in Barapatre, 2-judge bench in Barapatre said that where things have crystallized, we will not interfere, notwithstanding the 3-judge bench.
No, Barapatre is before. Barapatre is before.
But then we'll tell you. Thereafter, this very issue came up before the very same judge who had authored Honorable Justice.
That's Pradeep. Yes, please. That's Pradeep.
Why are you even talking? We may falter.
Chairman FCI.
Will come. Then, when the very same issue came up before Honorable Justice Chandrachud in a 2-judge bench, relying upon Bharapatre, he himself created that distinction. And this is in Pradeep. In Pradeep, he says that if rights have crystallized, then it's a totally different position. And this is how the High Court has gone into this issue.
Two preliminary answers.
You can understand that there are a large number of people whose matters are still pending there. It is open for you in those cases where rights are not crystallized in terms of judicial pronouncement to take up all pleas, including the 3-judge bench or the 2-judge bench. We can say that. But here we are from the view, prima facie, that you allowed things to rest. It is only because of the 3-judge bench you withdrew your circular, which you had issued earlier, and said that now superannuary posts will be there. That's it.
May I just explain this? As your lordship's last line, what we are saying is, we are not saying that we are throwing them out of the job.
Yeah, we've seen that. We've seen that.
I'll tell your lordship the reason why this, and the reason is this, because we created supernumerary posts because otherwise what happens to people who are genuinely entitled for the quota? The question is not one or two. Today we are faced with thousands of these cases and the court actually laid down the law.
Thousands of those cases will not come here.
No, there's a consequence is this. The consequence is this. All the protection orders, we'll have to produce the protection orders. We'll do that.
That would be very...
Because they gave an undertaking. Because in each of those undertakings, I see it from some of them. In each of those undertakings, there's an undertaking that he is not entitled to the benefit as an ST community.
No, correct.
So at best, what can be done is to protect the job.
No,
the job.
No, sorry, Mr.
No, I'll argue that. I'll produce those orders because I will argue this.
That may not be the correct. See, despite they gave an undertaking, the undertaking was taken on record, accepted, yet the High Court said that because rights have crystallized, this we can infer only from the subsequent judgment, that the rights have crystallized, therefore they will not be disturbed. That's what they say.
We'll produce the protection orders. Look, kindly see the great injustice that then happens to us. So far as people... The cascading effect, and I'll tell you, this is a genuine concern of the state. Suppose entry-level officer is recruited, his caste certificate is found to be fraudulent, High Court has protected.
You accepted it. See, only because there was after 7 years there was a change of the position. No, therefore, you did not accept the order at that time.
No, let me just explain. Because there was a full bench which is subsequently overlapped. I'm trying to articulate what the government's concern is. Because if genuine ST people are...
Understand.
So, for the next 50 years, because you can't promote these people now. You can't promote because these people are not entitled to any other further benefit.
According to you, their service will be protected, but they will have to be out of the cadre of the...
Of course, because otherwise genuine people and their pillars, otherwise...
Okay, just 1 minute. What about their emoluments?
Emoluments we have not taken away. It's completely protected. What we have done is we have created supernumerary posts. What they are insisting is that they will continue to occupy. Today, this is a fairly balanced with the status government.
1 minute.
The 10%.
One minute. So they would be entitled to all monetary benefits.
They will not be entitled to all the special benefits that accrue to them, including promotion on the basis of their caste. On their caste.
Except for promotion.
Except for promotion. Otherwise, what happens the next
1 minute? See, there can be two fact situations. They may not be promoted, but assuming that they were to be promoted, hypothetically assuming they were to be promoted, they would be obviously entitled to some monetary benefits. That you pay.
We'll take construction of this.
John, 1 minute. You are not arguing the matter. But suppose if we were to put it to the state, as you have by now you are aware what we have said, that hypothetically assuming that you were to be promoted till the time of your superannuation, you would actually not be promoted, but you would get the monetary benefits of promotion. Is that acceptable to you?
Yes. You also have to take instructions if they come by way of an affidavit. We take instructions.
But the problem is this.
The problem is you bring on record the protection order.
I'll do that.
Then only a proper decision we get.
I understand.
Because many of the employees, they have also retired now. That also is one of
Because we are not, there is no action for recovery, there is no action for retrospective effect to the circular. So I am saying today, our genuine concern is because for the next 30 years, this quota is blocked. I cannot promote
these 58 people, how many would have retired?
88 million.
88.
Give me 2 weeks time. I will produce the orders. I will give a tabular chart of which are the positions on which they initially came.
We have made some endeavor. We'll give a copy of this to you.
You oblige.
But there's a lot of blanks because
I understand.
The files which were uploaded.
No, we'll take you from the chart, the format of the chart. We will have it. Your Lordship will give us 3 weeks time. There's some intervening. And your Lordship will list this matter before the vacation. We'll have it disposed.
No, we'll give you not more than 1 week.
1 week, so it might be a problem.
1 week. Sorry. We want to.
2 weeks.
We were of this view. We are telling you.
I understand.
We were of this view that we are not inclined to interpret. But what has fallen from you, let us see. Let us see.
Because can I just ask for some more?
Because when we read the first file, that was a lineman.
I understand.
We thought that we thought that they were all class 4. In the time we saw this, then we said it is class 3 also. Class 4.
My lords, I appear in 22.67. Respondent in this matter has already retired and all the benefits were
That's
also.
all right. That's all right, ma'am. Let them come to the tabular forms.
My lords, I'm seeking withdrawal. I have instructions to withdraw.
Mr. Procedural, give this to you.
We'll do this. We'll do this exactly. I'm only praying that 10 days time maybe.
We'll give you 10 days. आपका नंबर लिख लीजिएगा और मेरे ऑफिस में email को लीजिएगा. By today evening, an updated this in format would be sent to you.
The only thing is, there are other petitions.
My lords, in item 22.67, I have instructions to withdraw.
Yes.
Sorry?
My lords, in item 22.67, I have instructions to withdraw.
No problem.
So far as other petitions are concerned, along with we sail in the same port, along with the state. So this is by transmission company, my friend appears for the Jilla Parishad.
Same thing will apply. Same thing will apply.
Yes.
Same thing. You also give your numbers, we'll have
Yes,
so that you can update it.
Yes, we'll do that.
And add something with whatever is part.
Yes.
You can also add the age of retirement.
Age of retirement. इसमें है
You can add the age.
In some of the cases, 58 and
Date of retirement.
58 and 60 with respect to age of retirement.
Whether they have retired or not, you enter that.
You also give your telephone numbers. We'll have it to you. Both of you sit down, see whether anything further needs to be added. Give it, add that in the column, so that Mr. Parmeshwar is in a position to give you a comprehensive. We'll also send it to you. ये काम करिएगा ना, छोड़िए, उस नंबर छोड़िए, इसी को आप फोटोकॉपी करवा के सबको दे दीजिए.
That would be better.
अभी दे दीजिएगा.
That would be great.
So that no one is left out, but all of you would have a cup of tea with the learned senior counsel,
Yes.
and give your suggestions so that a comprehensive chart is prepared. And you shall place on record copies of the judgments at that column. You would be having the copies of the judgments with you?
Yes. They can share it with whatever.
You would be having the copies of the judgments.
Not file the paper.
The original judgment in your
protection of that.
Yes.
So you do one thing. You give it to him.
It's in the SLP. 22.2, the protection judgment is in the SLP itself.
In 22, we saw it was not there.
Yes, 22.2.
That's all right.
Separate.
Please have a separate compilation of the judgment.
We'll do that.
Separate compilation of all the judgments.
We'll do that.
Large number of people will not. I don't think so that it will happen in coffee. He'll have to take us for dinner. With large number of people on the both sides.
Okay, only dinner, huh?
If I have to take instruction, I am for Jilla Parishad Lordship.
Instruction for after dinner or?
No.
I
I have
have
to
or what?
I have to take instruction from Lordship, my client, at least 3 weeks time.
No.
Lordship, there are other matters, Lordship, more than 30 matters, Lordship.
Sorry.
How to?
Sorry.
Lordship.
What we are dealing with only those.
Yes.
Where the Lordship may have a.
At least Lordship.
Any day after 10 days.
After 10 days, put it in.
Good.
Matters, in 4 of my matters, order is ready, and only the judgment has been given. Matters may be permitted. If it is ready, it can be filed today.
We have heard Mr. Permission for some time. List on as report, that is adjourned list on dash.
Great.
Some Tuesday. So Tuesday this year.
Item 23.
We are very clear, Mr. We are very clear. Comprehensive charts.
I understand.
We want to protect them. One thing which has weighed with us is, of course, that and they are ready. That as far as emoluments are concerned, somewhere via media, they are ready to give up, their promotional revenues.
So the quota can't be blocked.
They are ready to give up.
I understand.
They are only interested in money. That's it.
Item 23.
Even state as well.
Sorry?
Even state as well.
State should also give up something.
Even state as well is interested in money because ultimately everything boils down to the finances of the state. That seems to be the real reason.
No. That doesn't seem.
But because what happens here is this. Otherwise now this is a self-same creation and by the state. So
Anyhow, state did a mistake.
Well,
In item 23, my lord.
Just 1 minute, sir. Yes, sir.
My lord, I have a small predicament, my lord. I was led by Mr. Arvind Datar, my lord. He informed us in the evening that he is suffering with a bad throat, my lord. That's the only reason I mentioned in the morning also, my lord. I informed the opposite side as well.
About 15Z.
This one. The 2A. D. We are in, what we'll do is, you just ask Mr. Datta, of course he's not defending, we are aware. We'll admit the appeal on which of the questions?
Yes, my lord.
I'll
just inform you. Just give me a moment.
B, just check up with him and then we'll keep it for hearing on Sunday.
Lord, A.
No, you just check up.
I'll just check it.
Just check up with him.
Yes, ma'am.
You just come back, you'll just pass it.
Lord, may pass it over.
We are just passing it over.
Please,
you can also suggest which questions.
Lord, may I suggest a way, my lord? we both can sit together and like
If you get passing it over, just give it to us. We'll admit it and post it for hearing coming week.
Well, not coming week, but
Coming week means a week or 2 weeks or 3 weeks. That's okay.
That's right.
Lord, there are two matters, my lord. I am in the second matter.
Both these matters.
Okay.
Item 24.
My lord, sir, I'm requesting a passover in this matter. For the state, my lord. Hello, sir. Double AG Ms. Garma Prasad is on a leg.
Passover, no problem.
Passover.
No problem.
Great.
Item 25. Your Lordship, Senior Advocate V. Lakshmi Narayan is appearing through VC.
25. Yes, please.
My lord, I appear for the petitioner.
Yes, sir.
My lord, in this case, the state government has filed the counter, including the contesting respondent number 11. My lord, I may have to file some rejoinder, my lord, if your lordship could accommodate. Maybe 2 weeks' time, we'll file the rejoinder. But this is a case where the promotions have been given with retrospective effect, though they have not.
One minute, sir. If you see the additional document, page 25.
Yes, madam. 26 is the relevant part.
25, they have the appointment order. It refers to certain Supreme Court decision. Now, where is this Supreme Court decision?
That is, my lord, that has been overruled. That is exactly the point, connect. The Rangaya case has been followed.
Where is that decision?
Arjun 2007 11 SCC 605. That has been overruled by the 3 judges. Himachal Pradesh, my Lord Justice U. Lalit and the judgment rendered by my Lord Justice SANJAY. That is reported in 2023, 3 SCC 773.
Yes.
Honorable Justice Narasimha's.
Yes, my lord. His Lordship said the rule as on the date of filling of the vacancy shall be the guideline, not when the vacancy arises. That's the point.
Exactly.
In fact, 2012, the ratio was changed. 75 rules is not placed on record. I'll place 75 and 20.
Admit. Additional affidavit be filed by the petitioner. Rejoinder and counter there too. Be filed within 4 weeks. Counter within 4 weeks thereafter. Rejoinder if any 4 weeks thereafter.
Obliged.
26.
Lord, I appeal for the petitioner, Learned.
Sorry?
Learned AG, the Attorney General is leader in this matter.
No.
Should I request for
Passover? We'll give Passover, no problem.
Lord, he is on his legs in court number 8, Lord. I respectfully not seek an adjournment as per instructions, Lord. For a week's adjournment, Lord. In fact, when the counter has.
We can't adjourn now.
Lord, this counter has been filed only yesterday, but they received
it.
Please.
Can you see the last order?
Yes, my lords. My lords, I have filed my counter and I have raised that objection in my counter also. My lords, there is a special appeal that lies before the division bench in the Honorable High Court of Uttaranchal. So they ought to have pursued that before coming to the Supreme Court.
But this was specifically.
Why don't you do one thing?
My lords.
There's a suggestion that you take benefits. You leave aside monetary benefits from the year for the period 15th of April 10 to 12th of 17th of December 2015.
My lords, I will have to take instruction on this, but my lords, this is exactly what we are up against. Because my lords, this is,
How many?
In the state, my lords, I don't have instructions. This I'll get instructions. But my lords, here before you, there are only 2 lab technicians. A lot of them took. They filed affidavits which they have placed on record saying that they're okay with it being applied prospectively. But that is in complete violation of the judgment of the Honorable High Court of the 2014 judgment, my lords, which they have annexed as Annexure P1.
All other have been given benefit from 17 to 2015 only. And it was, but the appeals were actually not withdrawn, and they were withdrawn as infructuous. Thereafter, they gave the consent, and thereafter only.
Why did you not go to the High Court for intercourt appeal?
This was a precise question, This was asked by the Ashwell bench, Learned AG, he's reading us. But should I kindly adjourn the matter, in that case, For instance, we are looking at 17, 12, 2015, we are looking at that, They consent to that.
You tell the learned AG that.
What should I grant us liberty in that case?
Correct.
So grateful.
It is brought to our notice that in the High Court of Uttarakhand at Nainital, an intra-court appeal is maintainable.
Order 8, Rule 5.
Is maintainable. In this view of the matter, here is a considered view that aims of justice would be best met. The present petition is disposed of, reserving liberty to the petitioner hearing to file an appeal within a period of 4 weeks from. We clarify that if the appeal is preferred in the aforesaid period, the issue of limitation shall not come. Shall not come in the petition stands disposed of. We'll just be back.
Item 27.
Well, item 27, no count has been filed by the respondent number 1 and 2. Appearance has been given, wakalat has been filed in 2024.
Yes, please.
Well, I'm appearing for the state, well, let's see for which time to file my counter.
Counter you have not filed?
No, my lord.
Counter, the person filed 2 weeks, under 1 week, list on that. No further option.
That's it.
Item
Don't take any day for weeks.
Some date will be there after 3 weeks.
I'm on.
Item 28, your
28.
matter
There
has
are-
now become infructuous. May I
No.
just hand over the order of a coordinate bench which has been passed in Orchids? As far as the question is concerned, question of law is not a live question of law anymore because the patent has already expired. We have entered into settlements with the other parties. So today the question doesn't survive as far as we are concerned, your lordships. Coordinate bench, your lordships, in similar circumstances, that was a high court order, your lordships.
Identical order?
No, but this relates
With
to
regard-
some CB. This is for some.
No, this is completely different. I appeared in this matter. It's entirely
question
different.
is same.
There's simply no overlap. There is no overlap.
No, the question is the same whether it's competition commission or the special enactment that.
Why deprive us of the execution of this new branch?
Not just because, I'll just put it this way, because it would be, there's no consequent relief that will flow, because now the settlement is reached. The issue is with regard to.
Settlement right at between whom?
Between the parties, your lordships.
Parties to
between
the
us.
instant case.
The complainant who has approached the CCI and against whom the complaint was filed.
Just a minute.
May I just submit to
The
this?
complainant.
Here on, in the SLP,
Your lordships, the complainant is were our licensees.
one kindly come to page 60
Yes,
of the first paperwork.
yes.
Now, appellant number 1
Yes,
is Monsanto.
yes, your lordships. I'm appearing for Monsanto.
1 minute.
My case.
Number 3 is again Monsanto.
Yes, your lordships.
4 is Musi Vedu Steel Limited.
Your lordships, there are complainants are respondent 4 to 11.
Okay.
And then there are some seeds associations, etc. from 12 to 50.
So they have entered into an agreement.
We have entered with our licensees who were the complainants. So the pricing is with regard to the complainants
And
only.
it may not stick. We'll have to nonetheless say this here, whether it has become infructuous or not is something which we'll have to examine.
I can show you, lordships, how it's become.
May I just submit to this? Well, first of all, my lord.
And this is only with regard to Monsanto. I'm not appearing for Ericsson here.
In fact, your lordship, I'm appealing.
This is only with regard to Monsanto because my patent also has now expired.
It's all right,
So there will be no.
In Monsanto as well, my lord, insofar as this limited submission regarding settlement is concerned, as my friend is saying, there is.
She made 2 submissions.
Yes.
One is settlement. To leave that apart.
Yes.
She says her license is patent license was
Well, there is a larger question involved here. The impugned judgment lays down as a proposition of law that the Patents Act displaces the Competition Act. The two acts are ultimately repugnant, and therefore, if a complaint of an abuse of an intellectual property right by a rights holder is brought to the Competition Commission of India, that the Competition Commission of India is stopped from looking into that aspect.
So Justice Bakru's view is, according to you, is the correct view.
According to us, is the correct view, overturned.
We understand the view taken by Honorable Justice Bakru, according to you, is the correct view.
According to us.
And the view taken by the DD, authored by Justice
Waziri
is not the correct.
Is not the correct.
That's in short what
That's in short. That's in short the position. Now my friends have not filed a counter in this matter.
May not be.
No, very well. I'm just pointing. Yes. So so the larger legal question was perhaps the aspect of private settlement. I mean, on this settlement, can I just say one thing? What we find is these parties are essentially dominant players or large players. What we find is there are settlements, the contents of which are never shown to either us or to the courts. One day a statement is made that I have settled with the informant. Now, frankly speaking, what is the content of the settlement? What were the circumstances leading to the settlement? Whether the settlement clause at all really satisfies the rigors of anything, we don't know.
We will not go into the settlement, we will go into the jurisdictional issue.
Absolutely.
In fact, the settlement have culminated into settlement of litigation as far as eviction case is concerned.
May I just
But the
say-
question of law, it's a question of whether they have the competition commission as the
Your Lordship,
jurisdiction or not.
Just give me 2 seconds.
Yes.
Now, it's not just a settlement. We have now entered into arbitration.
So,
Arbitration
no
of
problem.
courts have become final.
And he'll be happy if we set aside the judgment of the.
Your Lordship may leave the question of law open as justice, as the other benches.
Because it lays down the law.
Yes.
So that question needs to be examined.
Your Lordship, what I'm submitting is that
Cannot house
in my case, if your Lordship sees Justice Pratibha Singh's judgment also, exercise, because there will be nothing consequent that will be arising. Your Lordship keeps the question of law open in a suitable case.
May I answer why it could not be futile?
So, तीन eviction की subject to what you say, insofar as Monsanto is concerned, we can record a statement that the patent is expired, and we can say that this appeal has become an infructuous question of law left open. One, in the eviction matter, the very same question would arise.
May I say something else? May I say?
Or left open to be considered the other connected appeal.
May I just say something on this? But our concern is this. Even with regard, I don't know, I'm not appearing in Ericsson, so I don't know the facts of Ericsson, whether patents are there or not. But on Monsanto, assuming for a minute that the patent is expired and all of that, even so, what we see is this is a Section 4 case, abuse of dominance. A dominant entity, the Lordship knows the parameters of it. A dominant entity abuses its dominance, derives benefits, distorts the market. Then, my lords, with these smaller players who may be licensees, seed companies, farmers' organizations, goes, my lords, and settles way down the line, having derived the benefit. I am saying, in Samir Agarwal, there is 2 points. Your Lordship said that this enactment, the Competition Act, is not an in personam act, it is in rem, in nature. That is your Lordship judgment in Samir Agarwal. Insofar as the harm that has occurred, and not just to the competitor, my friends are trying to make this an inter-parties thing. No. The Competition Act, when you say in rem, it is affecting the market at the end. Who, my lord, ultimately pays for that harm and to the distortion of the market? It is very well for my friends to say the patent has to be expired.
No problem. Let's have the flavor of the matter.
Yes.
The Lordships, may I just point out one section, just to satisfy Lordships? Yes.
Let's see.
Yes. Just section 3(5)(b), Lordships will see for a moment, prima facie, that's all I'm saying. Lordships will keep that in mind while hearing his arguments, because that is one section he's not alluding to, which specifically excludes Patents Act, makes Patents Act a special act. So as far as the judgment is also concerned, your Lordships, if we were to continue with the argument, I can within 2 minutes tell your Lordships later act, special act, and a special exclusion under the statute.
Let's see.
Before my letter should start, just if I can add in the Ericsson matters. He pointed out that this is a case of abuse of dominance. But what has not been pointed out, what is the abusive conduct? In Ericsson case, me approaching, filing a suit for patent infringement, seeking injunction, that has been called and questioned before the CCI as abusive conduct. So how am I approaching a court that in this case a high court can be considered as abusive conduct? That's the case in Ericsson. And in most of the cases, patent have expired, parties have settled. And in one case,
I beg to appear on the Ericsson matter.
Lord, may
just a minute.
May take only 1.5 minutes before all of it. So that
only note. In the Ericsson matter, the complaint is with respect to a filing of a suit where the learned judge issues summons, finds merit in the suit, and that's sought to be made a basis for a complaint before the CCI. Now, CCI can't say no judgment malas of the civil court, finding merit in my suit, issuing summons, considering the matter.
We will, Mr. Sethi, we'll examine it. So let us, we only thought, Mr. Sethi, you do these matters day in and day out.
My pleasure, Malad, my pleasure.
Many other matters.
But this is something which we want to brush our knowledge about. We wanted to be educated.
May take a minute.
Yes.
Your Lordships. Lord, if we put all these pieces as different pieces of a human structure, somebody extended hand, somebody extended leg, somebody will completely a different avatar. We have to take a human form and then deal with it. It has comprehensive 5 or 6 very critical legal issues.
We want to go ahead with it.
Yes, my only thing is, one part heard today in court, for the last 2 weeks, it's happening on international taxation on India, Mauritius, DTA. It's always on the other side. But this will take back-to-back 2 days. Please give 2 days, any 2 days. We'll start and we'll be ready. For pure legal issues, my lord. One, I'll broadly give you Lordships, my lord. My lord, when we have a competition law, which is, my lord, a public law for public benefit, whether a patent law which deals with, my lord, the contesting parties on their rights, eclipse the applicability of this law, which is for the purpose of consumers' welfare. It's a very important point. They keep on relying on Bharati Airtel. At least 10 high courts have clarified, including our high court in Flipkart, in the other WhatsApp batch, what Bharati Airtel to what extent it applies. So this is one issue which your Lordship may have to deal. We are really willing to do, we are willing to do, but not today, middle of a part heard. That's the only request I think, and it will take 2 days.
No problem. You will be required there at what time?
Well, Lord, I'm now always arguing. I'm there, Lord. I have finished my side. I'm going to be there.
Okay.
That's
we'll do one.
It's happening since last Tuesday.
Can we do one thing?
Yes.
We'll adjourn the matter. No problem. Yes. And we'll adjourn the matter for next week or week thereafter.
Yes. Yes.
No difficulties. But you'll have to make yourself free from all other assignments.
We want to be here.
1 minute. Monday and Tuesday and Friday. This combination is available Monday, Tuesday and Friday only. We are now proceeding with the matter. What we'll do is, your colleague here, we just hear him for 10 minutes. Maybe 10 minutes, Mr. Sethi and Ms. Makhija. Just to have a flavor of what the matter is about. That's about all. And then we will keep it for coming Tuesday.
It will be after 2 matters are there, Lord. 15th April onwards, Monday, Friday, Tuesday. If after 15th April, Monday, Tuesday, we'll do it. We'll be complete.
Learned ASG leads, may I just make a submission as an officer of the court, not as a counsel for the party, your lordships. The order which I have just passed to your lordships of the coordinate bench arises out of the order of the High Court I've just passed out to your lordships. Identically, in that case, your lordships, para 53-54. It has been specifically said.
We have told you, we want to educate ourselves. We want to brush up our knowledge on this.
Lordships, at the cost of all the bails and all the other matters, your lordships. This is, lordships have also said many times.
We may ultimately do the very same thing, but let us spend some time on this.
Lordships is judicial, valuable judicial.
Oh, well.
Single judge has gone in our favor, division bench has gone in their favor. So, Lordship has to resolve it and bringing legal issues on public domain. It's very important. Single judge is in our favor.
Law open as has been done over here. Then what is the difficulty? I do not see.
Let us.
There was, if your lordships, there may be.
As a priest.
We are inclined to proceed with it.
Very good, very good.
You may leave.
Any Monday after 15th, Lord, be ready.
After 15th, we are telling you.
Yes, Monday, Tuesday, Monday afternoon and Tuesday. We want to be ready.
हम ये देखिए कि 21 और 22 को हमने क्या रखा है?
Yes.
21 और 22 April.
Special bench, 21st special bench to Justice K.V. Vishwanathan. One matter is there. and part
21st.
21st. And
Or
on
20.
22nd, 2 special benches with Justice MISRA at 2 p.m.
High or Nittis ko?
Late high school.
Nittis ko pushri. What we'll do is we will keep it for 21st, but there is all the likelihood of the matter being
Spilled
over for 28th and 29th.
Will be completed.
Special bench.
The lordships will like fix it 20 and 29.
No, we'll have it on
21st, your lordship.
21st.
Very well.
Suppose if that bench is adjourned,
Please,
we can
it'll
replace
go
it
on.
on.
Very well.
Else, 28th and 29th, all of you please block your dates. We are telling you.
Very good.
28th and 29th.
And we'll complete it.
Lordships are replies have to come on record. We will make sure.
That will give you time, but let us
Very
give us 10 minutes.
Very good. Very good.
And any one of you who is required to, appear in another matter are free to do so. Someone can continue, please. Mr. Sethi is there.
Extremely.
Mr. Sethi, we'll hear you, please.
As a please.
I'm so grateful.
You just tell us what is the issue.
Anything.
Oh, certainly. Everyone, please. Mr. Sethi is there. Would you like to?
Yes, please. I can just give a flavor as well.
Yes.
Because this case follows raises the question of the possible.
Let us look into the two statutes first.
Absolutely.
Just tell us the statutes. That's
absolutely. Because there is the Competition Act on the one hand, there is the Patents Act on the other.
Correct.
So these are the two enactments.
Correct.
Today
we will only go through the statutory provisions.
Absolutely. May I just give the heads of distinction just to make it easier for your lordships? I can just give what according to me are the broad heads of distinction, which we will argue on the 21st, 28th, whatever it is. Lordship knows, just as a precursor to that, the purpose of the Act of the Competition Act, the Lordships will glean from the preamble and section 17. The ultimate purpose of the Act is, Manoj, for the Commission to regulate a market, not individuals, to regulate market behavior. The specific section we are dealing with,
what's your good name, sir?
Samar Bansal.
Mr. Samar Bansal.
Yes, please.
Yes.
So
one is the Competition Act.
Yes, please.
And one is the Patents Act.
One is the Patents.
Okay. Let's see the Competition Act.
Yes, please.
Which are the?
Section. Have the preamble first.
Yes.
To get a flavor of what is the purpose of the Act.
Yes.
Will have an act to provide, keeping in view of the economic development of the country, for the establishment of a commission to prevent these both practices having adverse effect on competition, to promote and sustain competition in markets, to protect the interests of consumers, and to ensure freedom of trade carried on by other participants in markets in India and for matters connected therewith or incidental therewith. Therefore, you will see a broad scope, market-based, not individual or participant-based, and consumer-focused, because that is ultimately the remit of this particular commission. Now, the specific charging section, Manoj, with which we are concerned here, primarily, was, Manoj, section 4. So, I may say there are three broad buckets which this Act regulates for us. There is section 3, which is anti-competitive agreements. That is, Manoj, in the nature of, for example, cartels, cartelization. It is in the nature of horizontal agreements and vertical agreements. So, agreements between people at the same level of production, that's horizontal, and people at two different stages of production, that is vertical. All of those, Manoj, agreements, if they cause, what is the term of art here is appreciable adverse effect on competition. If they cause those, Manoj, section 3 covers it. Section 4, Manoj will see, which is, Manoj, what we are more concerned with in the present case, is, Manoj, abuse of dominant position. And I'll just read that, Manoj. This is, Manoj, what we back in the day used to call monopolies, etc. 4.1.
Commission is there, the office is there, MRTP.
No, MRTP was done away with.
Who's there now?
Competition
Commission. So, Competition Commission is the spiritual successor in a way.
No, that office is now.
Oh, physically that office.
No, I used to practice.
On Shahjahan Road.
Shahjahan, but which office is there?
For a while. No. So for a while on Shahjahan Road, where the MRTP used to be, the compact, well, it was there for a while, was functioning from there. Then which is the competition appellate. Then that was wound up. And
person was Justice Sandar Ali then.
I'm told some Ministry of Corporate Affairs Perhaps is there. I don't know.
I spent a lot of time there. And
Lordships recollects it was like the barracks.
Correct, with a tin shed and all. Yes. I'm just
Section
yes.
3.
Yes, we'll read section 3 first. Yes. Clause 3 begins with clause 3:1. No enterprise or association of enterprises or person or association of persons shall enter into any agreement in respect of production, supply, distribution, storage, acquisition or control of goods or provision of services which causes or is likely to cause an appreciable adverse effect on competition within India. Clause 2 says that an agreement entered into in contravention of the provisions in subsection 1 shall be void. 3, my lords, is a presumptive section.
So now we'll come to section 4.
Yeah. Can I, my friend would just, what do you want to do? 3.5. My friend would like me to read 3.5.
Yes.
And we can come to this part of arguments about it. I will come to that later. That's an aspect of the arguments. We'll come to that later.
Lordships, I'll let him read 3.5.
Very well, I'll read 3.5. Very well.
Nothing contained in section
shall restrict, and what my learned senior would like me to read is the right of any person to restrain any infringement of or to impose reasonable conditions as may be necessary for protecting any of his rights which have been or may be conferred upon him under copyright, patents, trademarks, geographical indications, design, semiconductor, layout act, etc. That's it.
That's a specific exclusion.
Yeah, correct.
But anyway, it's there in 3, it's not there in 4.
Then comes 4.
Yes, in 4. Abuse of dominant position. 4.1. No enterprise or group shall abuse its dominant position. There shall be an abuse of dominant position under subsection 1 if an enterprise or a group A directly or indirectly imposes unfair or discriminatory subsection 1 condition in purchase or sale of goods or services, or 2 price in purchase or sale including predatory price of goods or services, or and then there's an explanation giving I just need not read this for the present moment.
Okay.
B. Limits or restricts production of goods or provision of services or market therefore, or 2. Technical or scientific development relating to goods or services to the prejudice of consumers. So therefore, in a simple way, if there's an unfair or discriminatory condition in the purchase of sale or in the price, or something that results in limiting the production or the R&D and limiting scientific development in the market. All of these are abuses of dominant position. So I just may point out what this means as a matter of practice. That there's a there's a 3-step examination. First, it is seen, my lords, a market definition is done. For that, the Act also prescribes relevant geographical market, relevant product market. Once the market definition is done, it is examined whether the particular player, the one who is accused, an opposite party in the parlance of this Act, is dominant or not in that field. Once it is found that you are dominant in the relevant market, then the analysis. Just pointing that out, that's the 3-step process. There's no serious contest here that they are dominant in the market. Anyway, that's not the subject matter of this particular proceeding. It is only the abuse that is there.
Which other section?
Yes, Manas. Then C also, then C is denial of market access. D is supplementary obligation. E is what we call leveraging, using your position in one market to enter the second one.
So basically, we are to deal in the instant case, we have to examine the intent to import of sections and applicability of section 6, correct?
Yes, of 4. And what I really said, your lordships are not ready to get into the merits of whether 4 is made out or not. Because ultimately, this was a challenge to the initiation of investigation. So we are not to get a merits. Section 4 is mainly what it is. There's also an aspect of section 3 which will come to separately. But here, the limited aspect is in writ jurisdiction. Ultimately, it was for my friends to show that there is no jurisdiction whatsoever for the commission to get into the question. The merits will be gone into as and when the investigation report comes out. The lordships are not to concern yourselves with the merits of the actual question. I'm just pointing that out as a matter of administrative. That's also just
now Patents Act. Do we look into that today?
Very well. I can. Or can I just can I perhaps give just a list of what would be perhaps the relevant, what would be the broad sub-issues that we may perhaps canvass on the next date before your lordship. In terms of the distinct statutory scheme of the two acts, we'll try to argue 5 or 7 points, 5 or 6 points. First of all, we'll try to submit before your lordships locus standi. A far broader category of persons can trigger the Competition Act versus those who can trigger the Patents Act. Therefore, if you hold a repugnancy between the two statutes, you will foreclose the rights of all those persons who could have gone to the Competition Act but cannot go to the Patents Act. That is going to be the first round of differentiation. My task is to differentiate between the two acts and show. Yes,
Can you just illustrate that?
yes, please. I'll illustrate that. But section 84, in the Patents Act, the Lordships will primarily be dealing with the section dealing with compulsory licenses. That is really the part even my friends are concerned with. Section 84.1 and 84.2 of the Patents Act state, my lords, that an application for compulsory license can only be made by a person who is interested in such a license, even if, my lords, he is already holding a negotiated license from the patentee, my lords. In contrast, my lords, section 19 of our Act is very broadly worded. Any person may come. There is no restriction whatsoever on who can come, what are the prerequisites, etc., etc. It is not merely the licensees who are aggrieved. So I hope I'm clear. If I am a licensee or someone who's a potential licensee, I can go and ask for a compulsory. That's ultimately what is held against me. That the controller of patent, when he does the examination for grant of compulsory licenses as per the division bench, conducts an almost quote-unquote identical exercise. That's the division bench only, not my argument. Does an almost identical exercise in the compulsory license as, my lords, the CCI does in investigation under section 4. My task, therefore, is to show to your lordships how the scope of these two sections is broadly different in terms of the scheme of law. Yes. That 19 is much broader. Samir Agarwal, your lordship's judgment, I already pointed out. In rem, any person, the lordship has already concluded that. We place that judgment on the next date of judgment. Lords, essentially, therefore, the short point here is, apart from, if this judgment holds the field, apart from prospective licensees, no other category of person aggrieved by exercise of patent rights can have remedy under, my lords, any statute. Because they can't go under Competition Act, they're not eligible under Patents Act. That is, my lords, the locus standi argument in a nutshell. We'll expand on all of these on the next date of hearing, my lords. Then, my lords, we have said, my lords, that there are certain sections of the Act, in fact, the very sections quoted in the include order, when read together, actually demonstrate a legislative intent that the CCI is the body which must undertake a prior determination of all anti-competitive issues. We are positing that the Patents Act itself recognizes that there must be a prior adjudication. The Patents Act contains no mechanism or judicially manageable standards for deciding when something is anti-competitive, and therefore, ipso facto, that determination must be done by the competent regulator. Now, for that, the sections I will request your lordships to have reference to, my lords. First of all, is section 83 of the Patents Act. If your lordship has it, I can read it.
Yes.
Yes. Because I am going directly to begin general principles applicable to the working of patented inventions without prejudice to the other provisions contained in this Act in exercising the powers conferred by this chapter. Regard shall be had to the following 50s. Directly come to F. F. That the patent right is not abused. Please note the use of this word. Abused by the patentee or person deriving title or interest on patent from the patentee, and the patentee or a person deriving title or interest on the patent from the patentee does not resort to practices which, now please note, unreasonably restrain trade or adversely affect the international transfer of technology. Now, my lords, the Patents Act has no definition of the word abuse. The Patents Act has no judicially manageable standards to assist a controller of patents to determine when there is quote-unquote unreasonable restraint of trade or adverse effect on the market. No judicially manageable standards within this Act itself, yet the Act talks about this. 84 compulsory licenses, which is a specific area of law that my friends rely on. And this is very crucial. I'm coming to 84, directly come to 84.6.
Yes.
Yes. Now, 84.6 says, laws in consider. Now, these are the specific factors to be taken into account by the controller of patents. In considering the application filed under this section, the controller shall take into account, I'm not bothering my lord with 1, 2, 3, 4, We see the proviso for a minute. It's very interesting. It's very informative. Provided that this clause
Will not be applicable.
yes, shall not be applicable in case of national emergency or other circumstances of extreme urgency, or in case of public non-commercial use, or on establishment of a ground of anti-competitive practices adopted by the patentee, but shall not be required to take into account matters subsequent to the making. I just come to this in a minute. I think that the import is apparent to your Lord, but may I comment on this after showing one more section to your Lord, which is 90. And I'll comment on 84 proviso and 90 together. 90 terms and conditions of compulsory licenses.
Okay.
91, in settling the terms and conditions of a license under section 84, the controller shall endeavor to secure. Now, please come directly to Roman 9, subclause Roman 9. So, 91, subclause Roman 9. That in case the license is granted to remedy a practice determined after judicial or administrative process to be anti-competitive, the licensee shall be permitted to export the patented product.
That's to the license.
And, ma'am, I'm just...
Anyway, carry on.
The purport of what I'm saying is this, friends. These sections were also added to the Act by way of the 2002 amendment. They were not in the original Act. All this compulsory licensing section entirely came post-trips and all of those things and came into the Act. Roughly at the same time, the Competition Act also is being amended, so Parliament is cognizant of both when they are doing it. My point is this, was 86, two things your Lordships may see. Those four scenarios listed in the proviso. National emergency, extreme emergency, public non-commercial use, etc. are all considerations of compulsory licensing external to the Patents Act, not internal to the Patents Act. Secondly, my lords, 86 talks about quote-unquote establishment of anti-competitive practice. I ask myself a question, who is going to do this? Who is going to establish that an anti-competitive practice has applied?
Therefore, you step in.
Therefore, I step in. That's the shot. Then, my lords, I rely on SR Bombay for judicially manageable standards. There are none in the Act. There are in our Act. As simple as that. Then, my lords, 90. Also, my lords, 90 is the clincher as far as I'm concerned. 90, which no doubt talked about one aspect of compulsory license, the Patents Act talks about determined after judicial or administrative process to be anti-competitive.
Third point.
Yes. Then, my lords, the third point, of course, is that the inter partes adversarial versus in rem market. I'm not going to dilate on that. We'll go into that when we come next, minutes. That is there. I'll also be pointing out the procedure of the CCI investigation and how broad it is. Section 36 of the Competition Act, etc. Natural justice, hearing, etc., etc. Larger number of parties, etc. I'm not troubling my lord. Also, I want to point out, Lordship may remember reading the concept of group. We can not only investigate an enterprise, but also a group.
Just
The reason I'm stressing that, I'm extremely sorry, is that the Patents Act will look at the patentee itself. The Competition Act, by importing the concept of group management, would not only look into the person who is abusing the intellectual property right, but take this in a cross-licensing agreement or a scenario of assignment. Even the parent company, an assignee, or anybody else, who may not stricto sensu fall within the four corners of the Patents Act. Once
broadly, this is a solution.
Yes, also the purpose of
these two are a broad solution.
Also, that the nature of harms, nature of harms that is sought to be remedied by the Patent Act versus the Competition Act. That's a far broader set of nature of harms. Then, also, although I'm not stressing very much on this, my learned friends were keen that I read out 3.5 and the part that there's a carve out made for IPR provisions. 4 has no such carve out, but I'm not going on that. That you may consider, may not consider. I am saying the scheme of the Act itself is amply clear. But also lay this out. Also, I'm extremely sorry. One last aspect. There are others, but just this is an important one. That's why I'm placing it. Two things, Milords. The legislative history of the enactment itself shows prior to this Act coming in, Milords, there was a committee, our Act, the Competition Act coming in, called the Raghavan Committee. which went into all the aspects of the Competition Act and what should be done. At that time, TRIPS was also coming in. There is a specific chapter in the Raghavan Committee placed before the division bench itself. I placed that before the division bench, where, my lords, the Raghavan Committee expressly examines the interplay of IPR rights and Competition Act and concludes in the very beautiful language I can't better. So may I just say, my lords, just that one quotation from the Raghavan Committee. There is a need to appreciate the distinction between the existence of a right and its exercise. During the exercise of the right, if any anti-competitive trade practice or conduct is visible to the detriment of consumer interest or public interest, it ought to be assailed under in competition policy law. This distinction between existence of right and exercise of right is essentially the core issue with the impugned order, which has been lost sight of. I will dilate further on this, but I've just tried to give a snap. Yes.
Thank you, Mr. Samir.
Can I just give our perception on this whole issue in just 2 seconds, Your Lordships? Your Lordships have seen the scheme of the enactment.
And apart from these 2 issues, we don't want your rebuttal today.
No, I'm not.
So just want to know any other issue which would arise for consideration.
Your Lordship, the issue is this, that with regard to this interplay between patent acts, the point which has not been raised by him, in the interplay of patent and CCI, it's not as simple as which act will have the primacy. What is necessary to be seen is that what is the scheme, and in case ABCD conditions under the Patents Act are satisfied, then what is the role of CCI? So that waterfall mechanism is also a thing which my learned friend has not alluded to at all. So the first issue is with regard to who will have first jurisdiction. And that is what is something which has been decided several times over. And one thing I just wanted to point out to your Lordships is that Lordships will see the dates when these enactments have come into force. Now, Chapter 16, your Lordships will take a special note of this fact, has been included in 2002. It's contemporaneous with the Competition Commission Act. And Lordships will also recollect that after great deal of study and reports, etc., this scheme has been worked out in a very detailed fashion, and your Lordships will recollect 2002 Law Ministry, what all they have gone through, your Lordships, to come to this scheme. This scheme is keeping Article 51AH in mind, that the scientific temperament has to be encouraged in the country. So how to balance both the things? The balancing is the inclusion of Chapter 16. And it was deliberately that first Chapter 16 controller will first have to determine that there is a flaw in pricing. That my agreement, my licensing agreement, if your Lordships will come to Section 84, just to give an overview.
Yes.
Section 84 very clearly says, at any time after the expiration of 3 years from the date of grant of patent. So during 3 years of grant of patent also, the public interest is not in question at all. Like Novartis judgment, your Lordships recollects with regard to drugs, etc. Cancer treatment, if your Lordship recollects that whole litigation where cancer treatment patent was held by this honorable court eventually to not to be patentable. But here, your Lordships, it gives a blanket protection for 3 years. Then it says any person interested may make an application to the controller for grant of compulsory license of patent on any of the following grounds. So what is the scheme? That when there is a scientific patent, anybody who wants it, I say even the seed company wants it, for example, then they have to apply to the controller. Then the controller will go into pricing, whether the pricing of the technology and the patent is sufficient or not. And that whole mechanism is given, and there is a requirement of reasonable requirement of public. So there has to be a reasonable requirement of public that it is needed. That assessment also has to be done. Now the fight over here is who has to assess that. It can't be both the authorities in conjunction. So this is what the scheme is.
You now got a flavor.
Yes, and second aspect, your Lordships, this amendment is subsequent. So there is a presumption that the legislature knows what is contained in the Competition Act. So they already know what are Section 3 and what are Section 4. Specifically, Section 3 also amended along with this amendment. So this entire scheme, your lordships will have to see and examine that what is the purpose across the two.
Thank you.
Enactments.
Thank you.
The reason why I was saying was that as far as we are concerned, your lordships, the price. Just one more thing I just wanted to reiterate. My learned friend in the Competition Act is saying that individual players are of no consequence. Now, unfair trade practice, your lordships, has to be played by people. If there is no consequence in effect, if commercial consequence does not follow, if pricing has no effect in this whole entire litigation, there's no consequent remedy, the relief that has to be granted, your lordships. Eventually, for us, your lordships, we are going to be only assisting your lordships in this.
Thank you.
Now.
Thank you, Mr. Yes, Mr. Sethi.
One short submission, Malas, you also may consider. But I beg to appear for eviction, which Malas is holder of patents and thousands of patents in mobile telephony network. Now, Malas, I have registered patents across the world and also in India. Now, Malas, I have a right under the Patents Act in Section 40A to sue anybody, Malas, who uses my technology without my authorization for an action, Malas, of infringement. So somebody, Malas, seeks to use, Malas, my technology without taking a license, infringes my patent, so I'm entitled to the Patents Act to sue him, Malas, to stop him by way of an injunction. And so I can file a suit for infringement. Now, Malas, in that suit for infringement, the civil court will consider my claim, return a prima facie finding, issue summons to the defendant. The defendant will contest that claim and either challenge my patent, Malas, or Malas, without challenging a patent, seek to raise a contention that there is no infringement. So if he succeeds, Malas, I will fail in my suit. If I succeed to establish a prima facie case, Malas, I get an injunction and of course a final decree in the suit. Now, Malas, if my friend's claim is accepted, because Malas, the complaint in the present case was limited to this plea, that the suit filed by me is an abuse of process. Now, Malas, will the CCI sit over judgment of the view of the civil court and undertake an exercise which may result in a final order overreaching order?
To what extent the powers under the Competition Act can be exercised?
Yes,
is something which we need to.
I'm so grateful.
Just one minute now. Now we have had a flavor of it. Now what we intend to do is, yes, we don't want you to say that we were not heard. But I thought Mr. Sethi was leading you.
Because your lordship was noting
Mr. Sethi was leading you. No? So therefore, that's all right. Now what we'll do is, that's all right. We broadly have.
Lordships, all that I'm saying is the lordships has Ericsson's.
Ericsson, Mr. Sethi was there.
Yes, your lordships, because that is a live issue for them, your lordships. So lordships will have their assistance. As far as we are concerned, your lordships will not require other assistance anymore, because there is no effect. It's not a live issue in my case at all. That is the whole thing.
Well, supposing you were to close the Monsanto.
Well, I tell my only concern, this would effectively be assuming your lordships hold enough.
Protect them. Lordships will say that.
I'm not on the question of law, I'm not on the question of law.
Yeah.
Assuming, my lord, that there is a harm already done by them. Assuming there is a harm already done by them, they are liable for penalties.
No problem. We would allow Ms. Makija to be benefited industry. So
I just one small question.
1 minute, yes.
Yeah, I'll have to thank Mr. Bansal for that.
So Samir.
Samar
Bansal.
Where are you from?
Delhi.
We have heard. We have heard. Briefly, we have heard Shri Samar Bansal, Mr. Sethi, Ms. Makija, Mr. Sethi. Then, the request of learned PhD, matters adjourned. Let the parties place on record their written submissions, not more than 5 pages,
Lordships, my counter is not on record.
Just 1 minute.
Yes.
Before the,
Great.
before the next date of hearing. We'll start. If any one of the parties have not filed their counter affidavit, they may positively do so within a period of 1 week from today.
Great.
No further opportunity shall be afforded for such purpose. The joinder, if any, also before the next day. The written submissions be positively filed within 10 days. Then list on
We make written submissions
10 days.
50, 10. A little longer after the rejoinder comes, so
How does it matter?
Lordship will have the
15 days. 15 days.
yes, yes.
15 days. List on 21st. But we are not saying 28th and 29th.
Very
but we are making it very clear.
Yes.
We'll keep it. Absolutely.
List on 21st. That's
so good. Request, my lords. My lords have filed 2 intervention petitions in the matter, my lords.
No intervention we will allow. We will allow you to argue.
My lords, in that, my lords, one is a Europe-based society, my lords. Other is an India-based society.
We will not allow any applications. Nonetheless, it will be open for you to assist.
Lordships,
So, my lords,
received any copies? They can give
We
it
are
to us.
only saying
It over to us. Yes.
we are not placing it on record. Interveners may also exchange their written submissions. That's all.
my lords, so does that maybe
Grateful.
Grateful.
Please, my lords.
Intervention applications are not being allowed. We are very clear.
Please, my lords. So, my lords, may indicate that I may be allowed to file my written submissions at least. Because otherwise, only the parties have been.
We are, even though we are not inclined to allow the applications for intervention, but however, we clarify that it shall be open for them to place on record their written submissions.
Most of them.
So copies to all of us.
Needless to add,
Yes.
I mean,
yes.
we did not say that.
Because we haven't got the intervention application also, so they should serve to all of us.
Which shall be
Serve to parties.
served upon all the learned.
Very good.
We'll be back at 2. Thank you.
Great.
Up to 29.
Please, Manos.
Three dates, three admitted dates, my lord.
Just 1 minute. Yes, please.
First is 30th January 1997 is the circular pertaining to compassionate appointment, my lord. So that is still subsisting. And my father died in the year 1998.
The best case is that at page 69 to 71, others have been granted.
Others have been granted, my lord, and moreover, page 66, my lord, page 66, my lord. They kept me in the loop saying that I will be getting the compassionate appointment. They agreed before the High Court also.
We have seen.
Yes, page.
The difficulty is
yes.
Your page 61, 62 is the application by the mother.
Yes, madam.
Correct?
Yes.
And then pension has been awarded on at page
application.
Just from
yes.
Now 63, 64 they withdraw the scheme and they say no compassionate appointment.
Yes.
But after a period of 24 years, the High Court has said, the only thing is that 3rd of June 2011, you get to know that others have been granted. Page 69, 71.
Yes.
You send a legal notice on 12th of July, 12th of September 2014.
They lifted the ban only in the 2013. They are admitting in the counter because there is a ban.
Please.
2001, my lord.
2001, when they did not comply with the direction, what steps you take?
Yes, ma'am. That page 65, page 65 for a minute. Page 65, ma'am.
They had to take a decision within 3 months.
Yes, madam.
No. So your second writ petition comes in 2014.
No. Then your lordship, they say that learned counsel appealing for the respondents contended that apparently there is no objection for grant of this relief to the petitioners. So they are admitting that I am entitled for compassion.
The question here,
yes, page 66, madam.
Assuming this order is correct,
yes,
because this is not in the challenge.
Yeah, no.
You have been sleeping over your rights for 14 years.
That page 66 for a while. Page 66 for a while. After this, my lord, they issue a letter this to me. That is 10th October 2001, page 66, my lord. What they said to me last para, my lord. I'll read the second para. Due to hard financial condition of the board, ban was imposed on granting the appointment to the one of the family members on the death of the employee officer working in the board white letter dated 17 so and so. Due to aforesaid ban, it is not possible to grant compassionate appointment to Rakesh so and so in the board. In spite of that, in such cases, in lieu of compassionate appointment, the board has approved monthly pension, which has already been granted to you by order dated so and so, and the payment is receiving to you in addition to compassionate allowance, additional pension of rupees 350 has been approved by board order so and so, which will be stopped after granting of compassionate appointment. Again, they say that I'll be getting the compassionate appointment, I'll be getting that annuity of 350 rupees. After this, my lord, what has happened?
Oh, that is right, but this cannot be kept indefinitely on.
Yes, because
this has to be within a reasonable period.
Yes.
See, your father died in 1998,
my lord. 8.
You made a claim in 1999, and then
yes,
you filed a petition for a decision on your representation.
Yes, madam.
Which was decided in 2001.
Yes,
after this order came.
Yes, madam.
Now nothing happened for 14 long years.
Yes.
You were eligible. It's not a case that you are not eligible and you were attaining majority and therefore your cause of action arose.
No.
Now what is the purpose of compassionate appointment?
No. What they say
to tide over sudden crisis in the family.
No, they are unnecessarily, my lord, they kept me in loop saying that you will be getting the compassionate appointment. Even 2001, they don't reject my appointment, compassionate appointment. They say that we will give you annuity till you get a compassionate appointment. Thereafter in 2013, your Lordship may see the counter, my lord. Your Lordship may see the counter. The reason what they are saying, page 9 of their counter, my lord. Page 9 of their counter, which they filed here, my lord. They themselves admit that the ban was lifted only in 2013.
You would be close to your own retirement.
50 years, 51 years.
I don't want to get
No, I understand. You can't keep me. There was no fault of mine. There was no fault of mine, my lord. I was continuously. Your Lordship will see the counter of page 9. Page 9 of the counter. Page 9. Yes, ma'am.
Two things. That page 65 order.
Yes, ma'am.
We appreciate that we told you your best case was page 69 where others were granted.
Yes, ma'am.
But and you sent a legal notice in the year 2014 only.
Because
1 minute.
Yes.
From 2001 till 2014, you could have pursued the matter gone back to the High Court as was directed at page 65. You could have gone back to the High Court and said, sir, I'm sorry, they are not giving it to me.
No, they were saying that there is a ban. That is why page 66, my lord. They are saying there is a ban. That is why we are not giving you. We are giving you annuity. We will give you a compassion. That is page 66, the spirit of the order, my lord. They are not disputing this order. What they are saying is now, because after this order, they lifted the ban. Page 9 of their counter, my lord. Page 9 of their counter.
What is the purpose of a compassionate?
I understand, my lord.
If the purpose is not served, then it is violative of Article 16. Where is the question of influencing it?
I did not opt for any other, my lord. I continuously. Page 9 of their counter. For a while, page 9 of their counter, my lord. Which they are admitting that. Page 9 of the counter, my lord. Lordship may see. Para 15, my lord. Para 15.
Mr. Bharat, for 24 years you have survived.
My lord, I have survived with a petty jobs, my lord. I have survived as an electrician only, my lord, with a petty jobs, my lord. But I can understand because they at least they should say me, they should tell me that you are not eligible. They don't say anything, my lord. For these many years, even no in the counter also.
Not of eligibility. There is no one is challenging your eligibility. What is
They gave a false promise, my lord. They said you are eligible for it. They are saying that you will be getting a compassion.
At that point in time, sorry.
No, your lordship will see one page 9 of the counter. Page 9 of the counter which they admitted.
No problem.
Yes, there are 15, my lord.
Yes.
There are 15, my lord. That since the appointment on compassionate ground was kept in abeyance by the STL board, the new formed respondent company came up with a new scheme of compassion upon 2013. So from 2001 to 2013, they did not, because there was a ban, they lifted the ban only on 3/6/2013, my lord. Then I came to know the final petition. That is why the single judge, my lord, page 142.
Sorry.
No, because they themselves were repeating it 13 years, they kept a ban. There was no fault of mine, my lord. Page 142, my lord, forever. The single judge, why it takes into picture? Page 142, my lord.
Now company is also changed. Sorry. Thank you.
Item 30.
Please.
Please, my lord, the action was happened. After that, I will.
Item 30.
Yes, Lordship.
Please. My lord, the action was happened. After that, I am a 60% candidate. But the trial court, everything is proved. The accident and also the police.
Question of 2.5 lakh rupees.
Yes, Lordship.
60.
6
देखिए.
Is the translation in paragraph 6 correct? Paragraph 6 of the impugned judgment.
In cross-examination, he clearly, categorically stated.
I had been driving the auto of Xavier so-and-so on hire. If that is the case, then there is no master-servant relationship.
Quantum is not an issue.
That's in probably.
What has held that he is not your employee? Simple as that.
Had been in the article of Xavier Selvakumar. Sorry, my lord, the translation is mistake.
No, we do not know. We can't read. Anyone sitting here who can read it to
Sorry,
be in a better position.
language is something.
Tamil, anyone who reads Tamil here in the court? Anyone here in the court? Because now is also there.
Now I cannot walk, my lord. I am 60%.
1 minute, we are just trying to see whether anyone who can read Tamil here. Just read this.
Just check whether the English translation is correct or not.
So there's one word, even in Tamil higher in English, that is written in English.
It's correct.
Correct. Thank you.
When the cross examination.
Then nothing. Nothing can be done.
The cross
the English translation is correct. And where is the question of employer-employee relationship?
Only one minute, I am an uneducated person. Then on the cross examination, he asked the yes or no. I say yes. I don't know what is he asking the English words in the hair. But I explain in the petition, my lord. In the explain. My lord, I am.
Thank you, sir.
My lord, can you see? My lord, uneducated person. I am the uneducated person. I don't know what is the meaning of.
We could have understood that had it been put in a language which you were not familiar.
Malad
has been put in that language.
Malad, can you see, Malad? The cross examination, the words is the question and answer come in the cross examination, not in the meaning. Malad, the cross examination, you put the question in the cross, what is the English in the words? I don't know. I am not the educated person. I am not the uneducated. I am the labor, Malad. Malad, can you? Malad, this is only 5 lakh rupees, Malad. I am the 60%.
Well, my lords, I appear for the respondent number 1 in this matter. I am seeking 2 weeks' time to file my counter, lords, on the main SLP and the application for delay as well. In fact, there's a substantial delay in the matter.
Delay we condone because the matter requires consideration. Delay condone. Counter affidavit positively within
2 weeks, my lord. If I may just, the reason why I'm saying the reply to the delays, my lord, there was an earlier petition that had been filed by them in 2021 itself. This SLP, they only challenged it in 2024. It's arising out of the same report. There's a second SLP.
The impugn order is not same, my lord.
Or may have the last order.
Your Lordships may kindly have the impugn order for a moment. I'm so sorry. I'm sorry to interrupt my learned friend. If your Lordships may kindly have the impugn order. The impugn order is, my lords, of writ petition 48727 of 2018 itself. And the High Court has relied on the similar matter, my lords, which is at para 2, page 34376 of 2018. So it's the coordinate bench. It has been relied on the judgment passed by the coordinate bench, which this matter is pending before this honorable court.
That has been entertained here.
Yes, my lords.
That matter has been challenged in 2021 itself. That is
all right.
Yes,
very good.
Which is that SLP?
Well, as that is SLP civil. I just
2756 of
2756.
It has been admitted now.
Yes, my lords. It has been admitted. 2756 of 2020.
Admit, tag along with swans.
I'm so grateful.
2756. And counter for 4 months.
4 months, sir?
Because it has been.
Yes.
Tagged, no?
Yes, tagged. Very well.
4 months, rejoined 4 months.
I'm so grateful. So good.
Delay condone. Delay condone.
Please, Lord, sorry, for the petition.
Is leave granted.
Lords, this matter arises out of a suit for specific requirements. Before I take your lordships through the documents, may I just indicate what my contention is? Lords, I am a public authority. I had published an advertisement calling for bids on a first come, first served basis for allotment of certain plots. Respondent made a bid. I have never issued any letter of allotment. I have never issued any letter informing them that I have accepted the bid. I have only formally accepted the bid. Along with that, the advertisement.
The payments also, na?
Because that was the provision in the advertisement itself, that at the time of making the application.
See, you didn't return it.
I offered it to them, they never took it.
When did you return it? When did you offer?
It was also offered before the High Court.
Few people came, gentlemen, now property prices have risen, so therefore it's a different matter. At that point of time, no one was coming repeatedly.
Your Lordships are right. At that time, perhaps the property price was about 1 crore. Lords, today it's about 16 crores.
Whatever it may be, but at that point of time, no one was coming.
I understand. Therefore, let me.
The entire amount.
Lords, therefore, let me. No, it's not the entire amount. With greatest respect.
And
the advertisement itself contemplated that if you make an application, you must deposit 25% of the amount.
So he deposited.
He deposited it. Now thereafter, what is contemplated is that if I accept this application, then he must deposit the balance 75%. I have an argument on maintainability, if your Lordships will consider.
Thank you.
Because I have a point in law, if your Lordships will consider. Your Lordship will give me an opportunity. Your Lordships will give.
Question of law. We are into the morality.
No, Lords, your Lordship, just give me 30 seconds, not more than that. Just give me 30 seconds. Lords, it's a public land. I may have a duty to.
We are not saying it's not public land. Suppose if the land prices are not risen, what you would have done?
Lords, therefore,
we put it to you.
I see what falls from your Lord.
Mentality of the state.
No, I see what falls from your Lord. I see what falls from your Lord. My contention before your Lordships really is.
He took chance at a time when no one was coming forward.
Your Lordships are right, but the question that I put to myself.
Yeah, question of law level.
No, my Lord, just for a moment, just 30 seconds, and I leave it at that. The question that really falls for your Lordship's consideration is that in the absence of a concluded contract.
We are aware of what yes. Thank you.
Very great. Sorry, may I make an alternate prayer? Sorry, I'm really good. Well, the alternate prayer is this. This is a pre-2018 transaction. Your Lordships have seen that the 2018 amendment will not apply to this. Now, I see what mistakes have been committed by me. But the land price at that time was about 1 crore. Today it is about 16 crores. This is ultimately public money. Would your Lordships consider?
Deposited during the course of trial.
No, my Lords, only 25% was deposited.
No, see, just 86 lakhs have been deposited.
It has been. My Lords, that is as per the market value in the year 2000.
So what do you want?
Would your Lordships consider putting some terms to them in terms of some higher compensation, higher consideration?
As far as that 86.
1 minute now, just
sorry.
To balance equity.
Yes, please.
What more will you pay? Simple as that.
Look, that's what I was coming to. That 86 lakh.
Okay.
Look, kindly.
Don't justify.
Not justify.
You give a figure what more.
That is the FDR has come to around 6.5 crores. Around 5.
What more will you pay? Simple as that. You tell us.
When did you deposit it?
Well, it was deposited in the High Court. If your Lordship sees.
What is the time?
Look, that amount, 86,88,000, was initially deposited by me in the trial court, and thereafter, on 2015 itself, on 2nd of September.
Some more amount, let's say.
50 more lakhs, because that amount comes to around 6 crores, the total.
8 crore odd million.
Well, I leave it.
Within 4 weeks.
Well.
Then Millard's only request, since your Lordship said 1 crore, if some more time may be given.
Okay. 2 months.
Lordship, 8. So that FDR amount also goes to them? No, that FDR.
Obviously, everything.
Lordship, please. Declare.
And the instruction sheets are the instruction submits that petitioner is ready and willing to deposit a sum of rupees 1 crore over and above what already stands paid by the also the respondent since paid by the since paid or stroke deposited by the respondent.
Lordship, your Lordship will only say what is to be paid in terms of the advertisement. Because my instructions are that 86 lakhs has not been deposited. I'm not, it's been refunded, I'm not joining an issue.
He clarifies that the entire amount stood paid stroke deposited with the court in terms of the entire amount as stipulated in the advertisement already stood paid by the respondent, paid stroke deposited by the respondent.
Wait, it's obliged.
And here, in the attending fact and circumstances, we are not inclined to interpret with the order. However, we clarify that the amount deposited by the respondent shall be released in favor of the present petition, along with the rest of the account.
Great.
Or in addition, some of these control shall be paid by the respondent to the petitioner within a period of 2 months from today.
Obliged.
Item 33.
Matter last week, I think. Lordship, may I seek a password in this? I'm being led by Ranjit Kumar. He said it.
Sorry. Item
33 is last Wednesday, my lord, Justice MISRA had heard this matter last week.
Sunata?
That's why I just wanted to indicate that. No problem. Leave it your Thursday.
List tomorrow.
My lord, last time Lordship had initially put on Wednesday. I have some personal difficulty tomorrow. Could it be Thursday? My lord, it won't take time for regular matter subject to matter. Thursday is the same.
List person. The list day after tomorrow. Day after tomorrow.
Yes. I have some personal difficulty.
List day after tomorrow. List on dash. It will come automatically.
Yes.
Authorized.
Obliged.
Item 34.
Please, Ballots. Ballots, I've received a counter from them yesterday afternoon. I'm not sure if it's on record because office report does not indicate so. But I also
what
have
do they say in the counter?
Please, Ballots.
What do they say in the counter?
My lords, they've just reiterated the impugn orders paragraphs. But I have to be fair to this court, my lords, white order 3.9, notice was issued only for continuation of delay. But they filed a full-fledged counter for this.
Delay we condone, we are not into delay.
Please, my lords.
Delay we condone. See, only thing which has come on record is that she was having 5 vehicles.
Yes.
The income taken by the High Court is MSCT took income to be 27,500 per month.
Yes.
Very well.
The High Court reduced it to 15,000.
Yes.
Why should it not be 27,500? For the simple reason that it has come in the statement while the issue was being considered that she was in partnership A and she owned 5 vehicles.
Yes.
And in addition, she was also having some other
Tailoring business.
tailoring business.
Tailoring business.
So what has been taken by the trial MSCT? We take that.
But the only issue is that she was in partnership with her husband.
Husband, correct.
And there's nothing to show.
So, but the vehicles were in her name.
Vehicles were in her name.
Correct.
But there's nothing to show any fall of income. That income continues. Whatever the business was there.
In fact, the MSCT has given 50 lakh.
Yes.
But as per our calculation, it works about 47 lakh 86,000.
Correct.
No.
We keep that.
Right. But the only issue is that.
You want to say something now?
No, there was the same issue about that. There's no document to show any of these income. We just have ownership of the vehicles. Nothing else is done.
Yeah.
No IPRs, nothing is done.
Thank you. We'll go into today's date as per chart. Today's data.
Please, Ballots.
Everything.
35.
Immediately, it's Manoj. Manoj, the respondent number 1 has filed the reply, so we have filed the counter. It's related to the interpretation of rule for the trading in Mandi. So respondent number 2 and 3, the state and Mandi, their replies Manoj awaited.
Sorry.
Manoj, this is matter related to the trade of garlics in the mandi.
No, correct. No,
Respondent 2 and 3 are
one minute.
I'm representing Arman, Your Lordship. I'm representing the.
The question is whether the schedule could have been amended.
Not amend the schedule, Your Lordship. That's my respective submission.
Let's see that.
Lordships.
Let's see that.
Lordship, may please see what he has amended. May I just take Lordships first to the provisions, just so that can be seen in the context of provisions. Lordship, may please see our counter. Counter gives the provisions page 22 onwards.
Statute itself.
I'm reading from that only, Your Lordship.
Let's
start with reading section 60.
Just 1 minute.
Lordship.
Kindly come to the statute which has been placed.
Your Lordship,
This is the IA, Statement of the Objects and Responsibilities.
Yes, I'm reading from that.
Now kindly come to section 6.
60.
60, sorry.
60. It says power of the state government to amend the schedule. The state government may by notification add to amend or delete any of the items of the agricultural produce specified in the schedule, and thereupon the schedule shall be deemed to be amended accordingly, provided that notification shall be issued under this section without giving in the Gazette previous notice of less than 6 weeks, as the state government may consider reasonable of its intention to issue such notification. But you may now.
Just 1 minute. Now kindly come to 81.
80 and 81 both.
Now come to 81.
I think 81 straight away, Lordship. Power of the director to direct making or amendment of bylaws, not schedule, bylaws. The difference is schedule and bylaws.
Just 1 minute now.
Lordship.
60 gives the power to the state government to amend the schedule.
Yes, Your Lordship.
81 gives the power to the managing director to amend the bylaws.
Bylaws.
Correct?
Bylaws.
One thing which you just kindly come to the schedule at page 27.
Lordships.
Now, what the managing director has done. Now, what was the schedule? What was provided in the schedule? 1 minute. We're just inviting your attention.
Yes, Your Lordships.
Now, Roman 7 is vegetable.
Fruits and vegetables. Yes, Your Lordship. Fruits.
Fruits and vegetables.
That's it.
And Roman 10 is condiments, spices, and others, which includes garlic, wet, and dry.
Lordships.
Correct. Now, this is the
crux of the matter.
This is what the act and the schedule was as prior to the date when the managing director exercises power.
Lordships.
Now, what is it that the managing director did? Let us see that.
Let us see, Lordship. 13.5. The order is dated.
Page.
33.
Page.
Page, Your Lordship, is 38.
Of this volume.
The SLP. Of the SLP paperwork, Your Lordship.
Let's see the SLP.
Lordships. Is annexure P4.
38.
Yes, Your Lordships.
Correct.
I read for your Lordship convenience. It says, using the powers conferred by section 21(1) and 2 of the MP Agriculture Produce Market Act, with the aim of establishing a better regulation system in the interest of the farmers for the notified agricultural produce garlic wet and dry in the agricultural produce markets of the state, the Agricultural Produce Market Committee is instructed to amend the bylaws year 2000 for the Mandi Samiti by 15/4/2015 and make a new provision mandatory, which says, Your Lordship, 16.7 that is added, that the agricultural.
Just one.
It says 16.7 that the agricultural produce garlic wet and dry is a perishable commodity which comes under the category of chutneys, spices and other items under Schedule 10 of Section 1A of the Agricultural Produce Market Act. Apart from the system, Your Lordship may please mark this, apart from the system prescribed in the above provision of this bylaw of the Agricultural Produce Market Committee, marketing, public sale, operations of the notified agricultural produce can also be regulated. So it is an alternative provision.
Please read.
Sorry.
What is that he has done?
Can also be regulated through suitable alternate transparent systems such as representative commission agent in the same manner as is provided in the provisions of the bylaws of 2000 for marketing fruits and vegetables, but nothing in this alternative shall make the agricultural produce garlic wet and dry
deemed to fall under Schedule 7 fruit or Schedule 8 vegetable of Section 1A of the Market Act. In case the Samiti fails to amend the bylaws of 2000 as per the above within a specified period, the said amendments of the bylaws of 2000 shall be deemed to have been made by the Mandi Samiti as per the provisions of the MP Krishi Upaj Mandi Act or the rules they are made thereunder, and thereupon the said amendments shall be binding on the Mandi Samiti from so and so.
Now, therefore, what is it that he has done?
Lordship, what he has
done is that garlic, wet and dry, has been brought into the category of vegetable.
Lordship, what he has done is there are two systems. He has given an alternate system that so far as garlic is concerned, that can also be auctioned in the open market.
How could he do? Because you see, unless and until the schedule is amended.
I bow down, Lordship, but the schedule, he is not, may I with great respect say, he is not adding it in the schedule. He is only saying that the mechanism that is developed, that is used to sell.
We are only asking you this. Does he have the power to amend the schedule?
Not the schedule.
Correct?
I bow down, yes.
If he doesn't have the power to amend the schedule, then the schedule categorically prescribes that garlic, wet and dry is distinct and different from vegetable.
The distinction, the reasoning behind this was because garlic.
Whatever be the reasoning, laudable object, we are not going to
just bear with half a minute. The reasoning is because it's a perishable product. What the managing director has done is he has said that the system of auctioning garlic, like we auction vegetable and fruits, can also be used so that garlic doesn't get wasted. If the farmers don't waste their produce with that intent in mind.
Does he have the power? That's
Lordship, under 81, so he's not bringing it under the schedule. He's only saying that this system, this management system can be utilized to sell garlic also. That is what is CC saying. He's not saying bring it under 10. He's not saying bring it under, under 7 or 8. What he's saying is that products which are sold under 7 and 8, because they are also perishable, and garlic is a perishable product, therefore,
That's a complete as.
I'll hand over the copy here.
You do one thing.
I'll file it.
We'll keep it day after tomorrow.
Gotcha.
We'll keep it on Friday. You get us
copies of the act.
A schedule, B the bylaws, and as you say that he has not tinkered with the schedule, he has only said that as per the bylaws, this can also be sold in the market.
Yes.
That's what it is.
In powder. I powder, yes.
So we put it to you, is there any restriction for sale of garlic in the vegetable market or not? That's the only
As vegetable or fruits.
Correct. That's the only question. So we'll have to just see.
Lordship, they are only
State also plays very important role.
It's respondent number 3.
And more in the and the High Court could have settled in a review, could have,
Your Lordship, in the review, why in a review? Because in the main order, these sections were not interpreted. In the review, the High Court has corrected that error. In fact, the state now has gone back to
adopted a very clear.
State has filed वकालतनामा Mr. Yashral Singh Bundeli.
Board के शुक्रिया, right? Just give the statute. से बड़ी गलती की हाई कोर्ट ने पहले डिस्कस कर दी, फिर रिव्यू कर दी और उसमें कोई रीजन भी नहीं दिए.
The review, they upheld the single judge's order. Yes. Single judge actually upheld
The High Court ought to have, while reviewing, ought to have dealt with every.
the single judge actually passed it.
Section 21 of the Krishi Upaj Mandi Adhiniyam. Section 21 of the.
No, Your Lordship, that is MP Agriculture Produce Market Act. I'll bring that also to the film.
That is the.
Yes, it's a different act. I'll bring that also. Page number 13, it said MP Agriculture Produce Market Act. In fact, Your Lordship, I've handed over the latest order of the state government. Is there, Your Lordship? Lordship, please see, they have now reverted back to the same position. It's dated 17/1/25.
What is it that they have done?
Your Lordship, now, because in the last date, the stay was vacated, so they have reverted back to the position to say that yes, 16.7, the provision that was incorporated was. Your Lordship has it? 17/1/25.
What is that they have done?
Your Lordship, I'll just read it in the exercise of powers conferred under subsection 1 and 2 of section 81 of the MP Krishi Upaj so and so. A bylaw amendment dated 13/3/15 was issued to insert a new provision 7 in clause 16 of the bylaws for the marketing of notified agricultural produce garlic wet and dry in the state's so and so committees. In relation to the bylaw amendment question, the copy of the order so and so is enclosed. As per the order dated passed by the Honorable High Court Indore, review petition and review so and so is effective. So they have brought back. They are saying that clause 16 provision 7 is effective in effect till the pendency of this SLP. So that's the state stand as of today. So state may need to file a response also on this, Your Lordship, because their stand also will be important.
Also the state now, they are having difficulty calling you. Just pass it over. Let's see if he comes. Because there is.
But Lordship, take it up on Friday, then we present the.
Just 1 minute. Suppose if he comes, then.
We'll be here, Your Lordship. We'll be here.
Is there a typographical error in annexure P4? Just check. Here you refer to section 21(1) and 2 of MP Agricultural Produce Market Act. And this original document shows that it is section 81(1) which has been involved.
Lordship, 81(1) of the Adhiniyam and this is 21(1) of the MP Act. But I'll anyway clarify.
No, if you translate from Hindi to English, the name would be.
Typo, it's 81.
Krishi is agriculture, Upaj is produce, and Mandi is market, so it is only English translation. So I think the act is the same. There appears to be some error here.
Lordship, the pastor will verify that.
We'll keep it for Friday then.
We verify this aspect also. Maybe there is a typo.
Correct. And make sure that the state is here. List on Friday. None insurance on behalf of the state. In the interest of justice of joint. List on Friday. You bring us the statute, both the statutes and the bylaws. Question is, the only issue is whether the MD has got the jurisdiction or not. Okay. That's about all.
We do that, Your Lordships.
Grateful, Your Lordships.
Please, Lord. This comes up after notice.
Your Lordship, may I kindly request for a pass over?
What is wrong with the order?
Yes, ma'am. Because this issue is no longer res integra. In fact, in my most respectful submission, in this case, it's a case of continuous default. So after the liability.
Wait, 1 more year, that can't be done, sir.
Not 1 more year, Brooks. The liability does not get extinguished.
No, it
Yes.
gets extended. That's about all. You want to
Yes.
get that benefit.
I'm grateful. That's my only submission. And this is the view taken by your lordships in Samruddhi. That this is a case
of the very same provision.
Not say, yes, Brooks. Though it was very same 10A. Otherwise, that was under MOFA. And this is otherwise IBC 10A. Because what happens is that in a case of continuous default, the liability, unless the amounts are paid every day, gives me a fresh.
Every year you will keep on amending.
No, this is a one-time. This is a one-time provision.
One time. See, then every year you will keep on amending.
Plus, that's my right. This is a one-time suspension during COVID.
Right.
Yes.
But you got that right.
Yes.
Because you decided you gave a particular date.
Yes.
And therefore you got that right.
Yes.
Right?
Yes.
Now you cannot say that I will keep on amending.
No, this is a one-time. What I say is that
one time you're getting it twice over.
No, this is a continuous. In case of a continuous default, suspension would only happen during the 10A period. The moment 10A period expires,
right, but then
it's a fresh.
Therefore, what you will do is at the end of each 1 year, you will keep on amending.
No, this is a one-time suspension only.
Right. But so, you got it for the year for which you filed an application.
Yes.
Declared it.
Yes. And I did not write one sentence. That's a continuous default, and therefore, in part 5, I did write this one sentence. I'm covered by Samruddhi. Plus, two is the moment the exemption period gets over, suspension period gets over, I get a fresh cause of action because the liability does not get extinguished. It is just that I can't maintain a section 7 for that period of 1 year. That's it.
See, 10A only gives you
suspension.
Moratorium, that's what all.
Correct.
Correct. And that moratorium is for a period of 1 year.
1 year.
And that moratorium is for a period of 1 year, start commencing from
25th of March 2020 to 24th of March 2021.
Correct.
So if it's a continuous default, the moment this moratorium, it's a suspension really, gets over, I have a fresh cause of action because it's a case of continuous default. And that's what your lordship say in Samruddhi. The default does not get extinguished. I can't maintain a petition for 1 year.
We are not saying that it will get extinguished, but what we are saying is that with the end of each financial year, you will continue amending your prayer.
No, this is, your lordship knows that it's the same period as in a suit. So if my cause of action survives post the suspension period, then I can maintain a section 7. Because the liability does not get extinguished. I can't maintain a section 7 during the suspension period. And that's the view taken by your lordships. And kindly have in part 5.
Given a date of 2020, 5th of September 2020, first?
Yes, September 2020,
now which you want to be substituted as?
As 1st of April 2021.
Correct.
Yes.
Now, when did you file that application?
When my petition was pending for NCLT.
Therefore,
I'll move in.
Yes. 1 year moratorium, you will.
I can't.
Extending by amending your petition says no, now it's.
If it is a continuous default, I can maintain a section 7. Only it's not a one-time default. And that's what your lordships have held. That's why the act says suspension. And part 5 I say continuing. default. I cannot amend if it is not a continuous default.
No, it is, we are assuming that it is a continuous default.
Yes. Then I have a right to amend. In Dena Bank, your lordships have held amendment in section 7 is maintainable. So therefore, my lords, maintainability is not a question.
In perpetuity, it will be extended, no, sir.
Because COVID was a one-time measure which gave a lease of life to defaulters only for 1 year. It was just a one-time measure. And therefore, if my cause of action subsists, otherwise the builder just one paragraph and part 5 I had clearly mentioned continuous default. May I read notes? Para 17, page 17, para 20.
Oh, what was the cause of action as per your original application?
Yes, Manoj. Because the cause of action was that the agreement gave me a right to recover monies from the builder, which was to the tune of 7 crore 65 lakhs. So the agreement stipulates that the moment you form a society, this money that the builder has collected will go back to the corpus of the society.
Just 1 minute. Just to answer what my lord has asked.
Yes.
Para 16 and 17. Let us read that.
Yes, para 16 and 17.
The tribunal has noted that in the original form itself, the date of NPA was mentioned as 31st of December 2018. Hence, as per the RBI circular, date of default was permitted to be.
No, this is dealing with another judgment.
Correct. Now, kindly come to para 17.
Yes, sir. The above judgment of the Honorable Supreme Court itself has laid down that categorical admission cannot be relied upon, but in a given case, it may be explained or clarified. The present is not a case where any clarification or explanation is sought to be offered for date of default 5/9/2020 mentioned in section 7. This is wrong. Application, the date of default in itself is sought to be changed as 1/4/2021 without there being any reason or cause. As noted above, the appellant themselves has stated that after registration of the society on 4/9/2020, the corporate debtor was liable to refund the amount to the appellants which default took place on 5/9/2020. In the application as period, they entered into informal talks with the corporate, which did not. One-fourth, because for March of 2021, I cannot enforce my section 7. However, if my cause of action is alive, then it gets ignited.
With your lordship's permission, may I just show 2 pages of the petition, my lord?
Just 1 minute.
third technical ground, which is at page 20, para 20.
Let's see the statute.
Yes, please.
Section
Section 10A.
10A. Let's see section IBC 10A.
The Honorable Tribunal just says one sentence.
1 minute, sir.
Yes.
And we are looking at 10A.
Yes.
You have not placed it on record?
I'm sorry, but 10A is.
IBC, Insolvency Bankruptcy.
Insolvency and Bankruptcy Code, 2016.
Yesterday I saw it, I think, maybe in a different book. That didn't note that.
Just a citation of Samruddhi also.
Your Lordships will find it at page 16 of the paper book in the impugned order.
16?
Yes.
16, my lords. Para 18 of the impugned order.
Correct, it is there.
It is there, yes.
The proviso is relevant, my lords.
Suspension of initiation of corporate insolvency resolution process, notwithstanding anything contained in sections 7, 9 and 10, no application for initiation of corporate insolvency resolution process of a corporate debtor shall be filed for any default arising on or after 25th March 2020 for a period of 6 months or such further period not exceeding 1 year from such date as may be notified in this.
Now read the proviso.
Provided that no application shall ever be filed for initiation of corporate insolvency resolution process of a corporate debtor for the said default occurring during the said period. Explanation for the removal of doubts is hereby clarified that the provisions of this section shall apply to any default committed under these said sections before 25th March of 2020. Now, let's
beyond this. So the default can't be within that period, but it can be after that.
I'm grateful. And in case of a continuous default, it is every day. The default gets ignited every day. And that's what your Lordships have held in Samruddhi. That and the learned NCLAT notes in para 20 says that you have not used the word continuous in your part 4, but I have used it in part 5. And that's why your Lordships issued notice. In the first order itself, this is what your Lordships say. Para 20 minutes at page 17. May I read now? Yes. When we look into part 4 of section 7 application as extracted above, part 4 of the application did not plead that there is no date of default and it is continuous default on the part of the corporate debtor. Even in the amendment application, part 4 date of default is sought to be amended as 1/4. There is no pleading of continuous date of default in part 4. Hence, arguments advanced by the counsel for the appellant that there was continuous default in the part 4 is only to save the position as barred by 10A, which cannot be accepted. So I have said in part 5 and not in part 4. That's the only error. But it is not that I have not pleaded that the amount is due and payable to me.
Where is your pleading?
Manoj, may kindly see part 4, which is at page 175, part 5. Part 4 is at 171.
It would be which annexure?
Which your Lordships have already seen. Date of default is 5th September.
No.
Part.
What would be the annexure number?
Manoj, the annexure is, what is the annexure number? It's a part of your Lordship. Plus annexure A3.
Part 5, yes.
Yes.
A3.
A3. And 171 is part 4, which your lordships may ignore. There the date of default is 5th September 2020. Kindly come to page 175, para 10.
Yes.
The corporate debtor has till date defaulted in transferring the amount as per clause 8, which was collected towards corpus fund to the said society and is therefore liable to return the same to the financial creditors. The amount so collected was far in excess of the required sum, and upon formation of the society on 4th September, the said amount as per clause 8 became due, which was not repaid by the corporate debtor. So therefore, my lords, it is an amount which has to be refunded to me in terms of the agreement, which has still not been repaid. So this has been held to be in the nature of a continuous default, which occurs every day that repayment is not done in Samruddhi.
Your Lordship, I'm sorry to interject. I'm seeking a passover. We are being led by Mr. Gopal Shankar Narayan. He's in a mitis and he's on his legs in court number 11. I apologize.
No problem. We'll hear him.
That's
Yes, sir. List on Friday.
how do you get?
Deeply over.
If I understand, I don't see state.
Sorry.
State की advocate आ गए हैं.
Again.
Your Lordship, I'm the for the state item.
We have
My
also.
My apologies, Your Lordship. I just rushed as soon as I got in. It was held up in some other court. Your Lordship. My apologies.
We have.
And in fact, I wanted to seek time, Your Lordship, in this matter to file our response for the state.
We have done it for Friday. Friday be ready. There is no counter required. It's only a question of.
Your Lordship, I'll assist. Your Lordship. And if possible, we'll file our written submission. And
please be here.
Take your mind, Your Lordship.
Item 37.
My lords, I want to seek some time to file rejoinder affidavit in this matter.
What rejoinder?
My lords, actually today itself we have received the copy of the counter affidavit because the service was affected on the earlier AOR, my lords. And in January the AOR has changed, my lords. So I want to seek some time to go through the counter
Let's see what is wrong with the order.
Settled position, in fact.
What is wrong with the order? Only thing is the earlier judgments also have been referred to and relied upon. Sheila Devi, now contract period services to be.
But my lords,
but
my lords in all those.
Sorry,
Is it?
Item 38.
High Court action.
Item 38.
Clause 38, although the counter was served to me well in time, I have instructions to file a rejoinder. Your Lordships are so inclined to give me time.
Actually, there is absolutely nothing.
Otherwise, I have you on minutes. I'll tell your Lordships what my contention is. My contention is, my Lords, these are allotment of tenement.
Just a minute.
Yes.
Can there be a conveyance in favor of the society or not?
In my submission, there can't.
Correct. There's a land.
Yes.
It has to be transferred.
Yes.
You say it can be transferred only in the case of an individual, not a case of society. They are a group of society. Correct?
Yes.
Is there any bar in transferring a land in favor of a society?
Plus, the fundamental point here is it's not a land. These are individual tenements.
Whatever it may be.
So individual tenements will be transferred to the individual allottee and the society under the rules.
Suppose if a group of people, come together, form a society and take benefit of the scheme of the government, and there is no bar, then
So the role of the society is provided in the rules. May I hand over the rules?
Actually, they've transferred lands to societies in many cases.
We have seen that. Your counter says that.
Many cases. And here they kept saying.
Those the 2016 rules are what will apply. I really have a submission only on these rules. If your lordship see, called the Goa Housing Board Registration, Allotment and Sale of Tenement Rules 2016.
Correct.
Now these rules have been framed under the Goa Housing Board Act. There is no dispute about that. Now your lordships will kindly come with me to rule number 18, which talks about a cooperative society. This is on internal page 1491. The paging is at the top. Page 7, I'm sorry, page 7.
Yes.
Your lordships have rule 18.
Yes.
Formation of housing society. The allottees shall form a society under the Goa Cooperative Societies Act for the proper maintenance, running and upkeep and keeping in good repair common areas and for carrying out current as well as urgent repairs towards common services. Now your lordships will also see 2 and 3. Neither 2 nor 3 under 18 contemplates that conveyance will be with the society. On the very same page, if your lordships also see Rule 19, Clause 4, the same page.
Yes, yes.
The allottee society shall have proportionate share of the undivided land of the prospective scheme or project subject to conditions that there shall not be any objection for carrying out any development by the board on the balance area of the sector as per the permissible FAR as and when required, and also the allottee shall not cause any obstruction to an official duly authorized by the board in discharging his or her duties in connection with the matter arising out of the management of the property. What are
impugned order?
Yes, sir. The Lord wants me to read para 4.
Para 4, 5 and 6. What
I'll
is
read that, sir. In 1990, respondent number 2 developed the land and constructed 60 higher income group double bedroom flats. By following the procedure, respondent number 2 invited applications for sale of flats under the said scheme. The petitioner submitted that the allottees of the flats decided to form a society, and NOC dated so-and-so was issued by the respondent number 2 to the chief promoter of the society for formation of the society for the purpose of maintenance of the flats at Durgawadi, Talegaon. These are 60 flat owners in 5 buildings constructed in the property. In the building scheme floated by the Goa Housing Board under the HIG scheme, the flat owners formed a society under the name so-and-so on 6th of March 96, which is classified as a housing society. The learned counsel for the petitioner submits that respondent number 2 was required to execute a deed of conveyance by conveying and transferring the said building along with the land appurtenant in favor of the society as per the plan approved for the project under the HIG scheme, for which numerous correspondences were exchanged between the society and respondent number 2 over the last 25 years. It is contended by the learned counsel that respondent number 2 disregarded and kept delaying conveyance on one or the other pretext. By letter dated 30th of April 96, petitioner society wrote to the respondent number 2 to demarcate the boundary as per the approved plan by the Planning and Development Authority and construction of barbed wire fencing all around the boundary. Thereafter, on 16th of July 96, the petitioner requested respondent number 2 to demarcate the boundary and construction of the barbed wire fencing for completion of sale deed formalities and handing over of the building to the society. By letter dated 21st January 97, the petitioner wrote to respondent number 2 for execution of the sale deed in favor of the petitioner and further requested that the petitioner shall give no objection certificate to mortgage the flats of the hire purchase allottees back to respondent number 2 until all their outstanding dues are cleared, to assist all the allottees who had purchased the flats on outright purchase basis but are liable to submit the copies of their sale deeds to the financial institutions from whom they have secured their loans. Thereafter, several correspondence was exchanged and the meeting was held in the chamber of the managing director. The petitioner, with a letter dated 4th of January 19, informed respondent number 2 that all dues have now been cleared by all members of the society, including the defaulting members, and respondent number 2 may now proceed with the execution of the sale deed in favor of the petitioner society. By communication dated 25th of April 9,
yeah, they've already identical. Sorry,
because there is a distinction between what has been done earlier. May I just address your lordship? No, I'll point out, Milos.
You want to harass them? That's
no, not at all. In fact, I have executed the allot. Insofar as the tenements are concerned, I have executed the conveyance deed. Milos, just one moment. Your lordship will just hear me for a moment. Please have a look at Rule 16, and I rest it at that.
Thank you.
Milos, just.
Thank you.
Milos, I have one argument on what my learned senior said about what we have done in the past.
Thank you very much.
So may I just say this and I leave it at that. I don't want to trouble you. I'll just say this. The distinction is that was done prior to 2016. 2016, these rules have come, which in my submission will be retroactive.
Does it prohibit? Yeah.
It does not expressly prohibit, but it does not allow me to do it because of Rule 16. Just therefore, Rule 16.
Thank you. Thank you.
That's Rule 16 only.
Thank you.
I'm sorry.
Lord, I'm 39 and I'm taking a pass on your lordship. Learned
Sorry,
senior
just
counsel.
a minute.
Learned senior counsel.
Landlord, who is the landlord? You're the tenant.
Yes, ma'am.
He's your colleague at the bar.
Yes, ma'am.
Take time and vacate. Simple as that.
Lord, learned senior counsel appears in this matter, ma'am.
You're senior for us. Take time, we'll pass over.
Lord, may grant me.
May
grant me a pass over, your lordship.
Only the learned single judge set it aside. Two concurrent findings were in his favor.
My lord, he has alternate accommodation available.
He's a colleague at the bar. Take time and vacate. We'll
My lord, may hear Mr. Senior Counsel Naidu.
Obviously, we are not saying we'll not hear you. As it is, we have another DB. So in any case, we'll adjourn this matter.
Yes, ma'am.
But we are telling you on Friday.
That too, my lords, the only issue is he's not, the learned single judge not gone into anything else but says no dispute.
1 minute. Why don't both of you have a cup of coffee and sort it out?
We will.
We'll try mediation. We'll try mediation.
You'll have it on Friday. We have a learned senior counsel is there. He'll offer you something else also. Mr. Naidu, merits apart. On merits, okay, let us tell you. Two courts were in his favor. Learned single judge, unless he holds that it is perverse, has reversed the findings. Be that as it may. Merits apart. He is your colleague at the bar. The other side is a colleague at the bar. Correct? Why don't you sit and speak?
Sure, more than willing.
We'll have it on Friday.
So be it.
As much time as...
Could it be Monday minutes? We'll have some breathing time in the weekends.
No problem. No problem.
Monday.
As much time as you want. Or if you go out and come back and say as much time we will give you...
No, Monday is enough. One weekend is, rather Tuesday. It will be on Tuesday.
Tuesday.
Great. Great.
Deeply.
Your Lordships, I am seeking a passover in the matter.
Passover in this matter, please see what is the matter.
The arguing counsel is on his leg.
2014 SLP.
Minute, I appear for the respondents.
1 minute. 14th of August 2015 order complied or not? Our order of 14th of August. Yeah, August order. Has not been complied. What is the matter? Otherwise, let us see. इसके का मैटर है वो कह रहे हैं गलती हो गई थी
W of excess. W of excess payment. What is it?
Sorry, we are not.
Your Lordships, may just pass over the matter.
Who's to argue?
The arguing counsel is on his leg.
What is the name?
Advocate Sahil Bilek, Your Lordships.
We'll mark his presence.
Your Lordships,
Your
Lordship may just pass over.
2 minutes we'll give.
Your Lordships.
Is he there? Yes.
I was also in personal difficulty.
बैठ जाओ ना.
All right.
कुर्सी नहीं है क्या?
Yeah.
तो बैठ जाइए please. Yes, sir.
My lord, there was an order of this honorable court dated 14th August 15. That has been complied, my lord.
Be that okay, complied with no. What else?
My lord, the difficulty is only this, that this was a typographical error. We have put on record.
Question of law left open.
My lord, put on record
the attending facts of this case, leaving the question of law open.
My lord, let it not have any precedential value.
We are saying so in the attending facts of this case.
Grateful.
Thank you. Thank you.
Item 41.
At 4 o'clock, if you at 3:30, if you are smiling, we are very happy.
Malad, in item number 41, there is a development, Malad, during the pendency of these proceedings. A section 7 proceeding was filed against the respondent and Malad, moratorium has been declared. But I can just share the order of NCLT, Malad. This is order dated 17/1/2024, by which the Malad respondent is now facing insolvency proceedings and moratorium has been declared. So Malad, either these proceedings will have to be adjourned, signed at
We will do one thing.
I was, in fact, requesting for some time.
No. What we'll do is we'll say that in view of this, we dispose of the present petition, reserving liberty to file afresh on the same and subsequent.
Lordships, may I?
Absolutely, Malad.
May I request for an accommodation for a week, my lords?
Not for.
Not liberty.
He is giving you liberty.
Lordships,
that liberty is also
because
the subsequent SRA has come in. He is purchasing the company, my lord, with as is various basis. If they have any grievance, my lord, they can file their claim with the IRP. IRP will now decide whether their claim.
I can verify also that about.
But I can share the copy of order with my friend if he wants to verify.
Lordships, this is 1 week's time, my lords, because I've been
Invite sir has placed on record.
Because Mr.
Just a minute. We are having it for Monday.
Lordships.
Order dated 17th of January 24, passed by the national company NCLT in case number so and so. And counsel for the respondent further submits that the petitioner can now agitate the issues in the insolvency proceedings.
Before the IRP. Before the IRP.
Before the IRP.
Because we have been suspended now, so I can't technically even appear in the matter.
To obtain instructions, list on dash. Monday, Tuesday, Thursday.
Item 41.
Obliged.
But I apologize, but in this matter also, Lord, I'm seeking a short adjournment.
What for?
The instructing officer, Lord, there were some talks internally whether we wish to pursue this any further, but the instructing officer has left the organization. Lord.
In view of this,
just a week's time, Lord. Let me have it after a week.
in view of this subsequent judgment of NCLAT in Mayfair, as affirmed by this court.
Lord, may I only say, Lord, this has become, in the facts of this case, this has become an academic question.
Correct.
Because, the respondent certificate of registration as an NBFC stands cancelled. So as on date, the respondent is not a financial service provider.
Correct.
In fact, in a separate matter, CIRP was admitted. That order has been stayed by NCLAT. So those proceedings are presently pending before NCLAT. So that's the facts which are there, and I have moved, in fact, in application.
So the respondent is not a financial service.
No, not as on date. It is not.
But as on the date when.
As on the date, there was a certificate of registration as an NBFC, but my argument was that a functionality test should be undertaken to see whether it is indeed providing a financial service. But be that as it may, today I am requesting for a short accommodation. May have it after a.
We'll also request you to see the decision of
in Mayfair.
In Mayfair.
Very well.
And also Jindal. Mayfair came before this court and Mayfair was affirmed.
Right, ma'am. But in view of the subsequent events that have happened, I would try to persuade my lord to
every adjournment here pains.
I'm sorry. I'm so sorry, but I apologize, Lord.
The adjournment business is not healthy for the institute.
Lord, I wouldn't have done that, Lord, but I do not have instructions today as to how we wish to proceed.
You knew the matter was there. Anyhow, we'll adjourn it for Monday, but we are very difficult to adjourn the matters. It pains us, honestly.
I apologize, Lord.
And it costs the litigant much. Monday ke liye rakha.
Grateful.
Special bench. 43 क्या है?
I'm 43 for the appellate. This.
It's a question of penalty only.
No, my lord, penalty based on a question of law.
Which notice was issued on
correct.
Penalty.
On penalty, but not only on the quantum of penalty. Whether penalty under the section can be imposed as a question of law, my lord, I want to place just I'll take 10-15 minutes, that's all.
That wasn't the argument was on.
My lord, that I had appeared on the day, I can tell your lordship, we had placed two sections. Question is whether penalty can be levied at all under those sections.
Gentlemen, you did not disclose that proceedings under the Forest Clearance Act were not under the environmental law.
So correct, my lord. So whether, my lord, that.
Yes, why should we?
No, I'll tell you, my lord. So that under the then. So two answers, my lord, two answers to that I wish to give to your lordship. First.
Today may not be a good day.
No, I'll take it next time.
We are just telling you.
No, I understand.
We are indicating.
Yes, I'll keep a list of dates ready. Yes.
We are telling you today.
All right, so this is what I have to meet. I'll answer. No. I'm not at all saying so, my lord.
Forest clearance he did not disclose.
My lord, whether that was the requirement under the then extant regulations is one question. Whether, my lord, even suppose I don't disclose, whether even then penalty.
You are in the business of extraction of iron ore and you don't have forest clearances, you don't disclose that.
That is what I want to show to your lordship just by way of 2 or 3 documents, that's all.
Shall we put a quietus today or?
No, my lord, please don't do that. I want to at least convince your lordship. Please have it on. I am ready to do it today, but the lordships don't have the time today. So, and next week is also fine, whenever.
No problem. Friday.
As they say, saved by the bell.
We live by the day.
Saved by the bell, or I get another opportunity, that's for your lordship to decide. Friday already.
My lords, could our matter in item 44?
Yes, please.
My lords, could this also be listed for Friday? We can grateful.
I'm sorry. But that Friday I have some personal privilege. It's on Tuesday.
Just item 44.
In
no, you are in the item 44. We are aware of it.
Look,
my lords, I have
43. Monday, Tuesday, whatever.
Look, Monday is a holiday, so automatically
Tuesday.
So instead of Friday, Tuesday.
My lords, item 44.
Just 1 minute.
Yes.
Mr. Singh, why should we interfere? You tell us that.
44?
Correct.
In 44, your lordship should interfere because of several big, large constitutional principles. Principle number 1, that your lordship has held repeatedly that nobody has a fundamental right.
Employees are not.
Nobody has a fundamental right.
Well, bonus was part of the statutory right.
We don't. I don't know, my apologies, I'm not familiar. What's your good name?
Karuna Nandi, my lord. I'll wait for my turn.
Yeah, please.
So what is the principles are?
Okay, we are just.
Therefore, I understand.
For the
principal respondent.
Mr. Bhattacharya, just 1 minute, please.
But I have also we have not got DA, there is a.
They have got DA.
No.
They don't want,
No.
they want the enhanced DA at the rate of the central government. That's the. What they want DA? They're getting DA at the state government rate. That's the only issue.
Then up until.
And the state government has a liability of 40,000 crores by saying you have fundamental right of central government.
That's no ground.
That's
no ground.
The right to
Say, don't have this.
The right to receive.
It's a constitutional issue.
We are asking him,
All right.
why should he even,
Lordship was scaring me in the last.
no, if you want, we can admit it, no difficulty. This is what you want.
Yeah, my lord, sir.
It should be actually post-leave, but I will argue before that. I will argue before that. It's a post-leave matter actually.
Next Tuesday.
No, but there is some, kindly give me 20 seconds.
No, no, sir. Obviously, we are turning the matter. उस दिन कुछ रखा तो नहीं है, इसमें time लगेगा.
Would the Tuesday after that be possible?
Then you have to take a chance. It will be.
No.
It's a post-leave matter, post-leave matter.
Next to next Tuesday, go.
8 to 15 दोनों को है. Special bench रखा हुआ है, time taking matter.
Yes.
Then maybe any day after 10th of April.
I have to open, kindly let my learned friend not say dates for me.
Just give us some details. But Tuesday. Any
Maybe kindly excuse me, maybe after 10th of April, I have some personal problem.
What is the lordship?
Any date after 10th of April, that can be.
We'll have it on 15th.
15th April, right?
Only one request, Milord. I am on the board, Milord.
Bench should be only, or we can have it on 14th.
14th or 15th?
Monday. 14th is a Monday. Well, not lordship. I have it on 16th or 22nd.
16th we can't.
22nd.
15th is all right.
No, but I have to-
22nd is all right.
I have to open the matter. Let it be 22nd.
Why is it
23rd.
20.
Only I am on the board. Because the workers are suffering. So that is the only request.
I have
2009. One more thing. Mr. Raju passed over item 14. I was there. So lordship put a date for this that. Mr. Raju is the one who saw it possible. 22nd, 23rd or 24th, whatever it was.
Item 10.
And that we, one second.
इसको रख लीजिएगा. Can we have that on 15th? We'll see. So we'll have it on 15th.
15th, and we have this is the same.
Suppose, just in case 16th the bench is constitutional.
There was also 23rd, but the lordship having the other one 22nd.
No, 23rd we have kept some other matter.
Yes.
So what we'll do is we'll have it on 15th.
Pass it over something. Very
15th के लिए.
Lordship will keep that in mind.
My lords, might it be possible to keep it high up on the board?
We've said high up on board. We already said that.
So,
Because there's some implement calculation.
No implement. We'll allow you to argue.
It's a legal matter. I have to understand that. Either have it on 16th, 22nd, 23rd, 24th, whatever suits my lord's calendar, or 29th.
Only 15th.
Only 15th.
15. If you are in difficulty, we'll accommodate.
It's not that kind of a matter, whether the learned friends are all that.
If you are in difficulty, we'll accommodate you. No difficulty. Thank you. Or we can have it on 14. 14, you take 14.
14th,
Another matter.
14th, I'm told, right? Sure. It's supposed to be Ambedkar Jayanti.
But it's not a holiday as of now.
It's likely to become 15th, to become a Monday.
Possibly, if it what वो जो पहले वाला मैटर है
Maybe.
उसमें पास होगा वो 14 के लिए 14
Which one?
14
Item number Monday. This is a Monday.
44.
Lordship not either West Bengal or Monday. This is
No, no, not West Bengal. The other, Mr. Raju's matter.
Very good.
Past our matter. 14. Thank you. Rest all matters may date.
He'll be here in a moment, I'm sure.
Yes,
I can start, my lord, but in 15, 17 minutes.
No, Mr. We'll request you to, we'll sit over. So we want you to.
What time is a little, I don't know, I can start, my lord, but.
You said initially 20 minutes,
No, in fact, I'm not going to haggle on that, but it's not going to be possible. I mean, it's not.
Start.
Anyway, I'll start. So, my lord, I have my additional written submissions I have given to your lord.
Not additional, I think you'll have to recraft them because now it's on a totally different point. The 4 proceedings which have taken place.
I will show those.
Basically, they are now on the 4 proceedings which have been initiated between the parties in the past.
Out of the 4 proceedings, 3 do not concern them at all. 3 do not concern them. Only 1 proceeding, which is final, which decree has never been challenged, and which even up to date has not been challenged. They have given up regarding that land in writing in their written submissions in the High Court. Of course, this court is the only court where anything and everything under the sun can be argued, forgetting what is your pleadings and what is your case set up in the High Court. Now, my lord, therefore I will take your lordships. I have made a very brief written submission. And why the court?
Our only request is, don't call them additional, make them in one go.
All right, so I will make them one go. But what I have given, let me start with that because it's very bullet point and it's very to the point. It says I have already filed them. It says additional written submissions.
You carry copies?
And we carry copies. What copies? We got copies. Just give copies.
And we have a copy as well.
Huh?
This way.
Vicky, photocopy ज़्यादा बड़ा है. You have one more copy, man?
Yes, give.
Yeah, just give us 2 copies.
Oh, that's got notings at the back.
Huh?
That copy seems to have a lot of notings at the back, subject to my eyesight. The other one.
Oh, this copy. इसके पीछे नोटिंग, आपके कॉपी के पीछे नोटिंग.
कुछ नहीं, आप इसकी photocopy.
Problem.
Yes, it's got some noting. Just change the last page, madam. Madam, last page photocopy. That's all. That will work. Just saying filed by. Yeah. छोड़ दो. Last page हटा दे. That's all.
Can we have a copy as well?
Yes. We've already handed it over to me.
No copy.
Anyway, I'll just give them. Let me just start, whatever.
Start.
Now, Lord, what we have done, we have explained it property-wise because both judgments of the High Court proceed property-wise. Now, there are a total of 5 properties. 2 properties are at Polpur and the dairy plot at Sonipat. It is their own case. Now, let me just read it without adding anything. A, property number B at Polpur and C, dairy plot at Sonipat do not exist. No cause of action arises qua properties B and C as observed by the learned single judge and the division bench. The plaint does not disclose any detail or exact description and areas cross-referencing with municipal revenue records. In fact, the petitioner in her replication admits she has only heard of these properties. She does not have any document pertaining to these properties in her possession. She further states that it has come to her knowledge that the said properties were disposed of by her brother Anup Singh in 57-58. Even during the pendency of the first appeal, it was conceded before the division bench, as recorded in the order dated 6 July 2017, that the appellant does not have any detail with regard to the land at Kolhapur and dairy plot at Sonipat. That order I will just read to your lordships. Please take that order. It is in the written submissions filed by respondent number 3. That order is very, very crucial. Please have page 6 of those written submissions. It covers 2 or just kindly see that order for a minute. It's page 6 of the written submission. It's an interim order. So we have 2 more. Just give page 6. Already given, but just quickly, if my lord scroll has them, or I just want to read this one order to your lordship. 6 July, it covers a number of properties and it gives their case.
And we have a copy of these submissions.
Yes.
And the earlier ones.
Everybody, anyway, everything is given, but anyway, we will give again. Now, kindly see page 6. Please see page 6. This is the order during when the LPA was still pending, 6 July 2017. Counsel for the appellant, that is them, states that the appellant does not have any detail with regard to land at Kolhapur and dairy plot at Sonipat. The property at Bhaktao as per appellant was sold and invested in house number C38 Anand Niketan. This leaves us with the property at Barota and house number 38 Anand Niketan. Counsel for the party state they will file written submissions dealing with the two said properties with regard to the interest of the appellant as well as the question of limitation. Let the written submissions be filed within 3 weeks. Parties will exchange written submissions. It will not be necessary to await submissions, etc. So, on 6 July 17, when the latest patent appeal was pending, the claim was reduced to only 2 properties. Now, we're not coming back to these bullet points which I have made. Now, what I have stated here, and I will quickly take your lordship to the judgment. For your lordship's convenience, I have noted single bench in the judgment P27 at 387 para 3 and 402 para 11A precisely records these facts which I have extracted above. The division bench order of 6 July I have just read.
Mr. Patwalia, they are admitting that they are only concerned with 2 properties.
So
in fact, their offer today is only with regard to 1 property. If you are willing, they will settle with 1 property only.
No.
So they are only confined to 2 properties.
So therefore, that's all right. Yeah. That's all right. So now we come to the Bhaktao land. So I'll read it quickly.
Is that correct?
Bhaktao has come to Anand Niketan. Bhaktao has been sold.
That's correct. No, we are dealing with Anand Niketan. We are dealing. And Barota only.
So, by now I know their case, Lord. I was quietly listening.
That is your offer, but even without the offer, you are restricting it to 2 properties.
Because Bhaktao has been sold.
Correct. So only 2 properties. So therefore, you need not labor hard on this point A.
Then I can leave point B also.
Point B also.
So because Bhaktao is also given up, which is the correct. So now let's come to Barota. Now let's come to Barota. So far as Barota is concerned.
But now the only question what they are saying is that is admitted by you that the sale.
I have admitted nothing.
The sale proceeds have been utilized to buy.
I have admitted nothing.
That's the case.
I have admitted nothing. They say in their rejoinder. Therefore, I will read this also. Please allow me to read B. I have admitted nothing. It is their case in the rejoinder, and Anand Niketan I will separately deal with. But my friends will. It's either only they are heard and your lordship will decide. That can be.
Mr. Please.
Yes. Or both sides will have to be heard.
No.
Yes.
Only you will be heard.
All right. I mean. That's all. No. It can also be that. Yes. So now kindly come to B. So therefore I will talk about Bhaktao. Bhaktao does not exist having been sold to purchase Anand Niketan. It is the case of the petitioner, not ours, that Bhaktao land was sold and property at Anand Niketan was purchased from the sale proceeds. Petitioner's admission to this effect has been recorded by the learned single judge in para 2 of the judgment and the impugned judgment. It is admitted before the division bench as per order recorded 6 July 17. Property in Bhaktao as per appellant was sold, and so therefore it is their case in the rejoinder. Their admission before the division bench was sold and invested in house number C, and I have given the pages also. Now single judge's para 2 at page 386. Division bench order is dated 6 July 2017. Para 6 of the written submissions filed on behalf of respondent number 3. Then the division bench in the impugned judgment, I will just broadly refer to. Now we come to the Barota land. Now, before coming to Barota land, actually I can come to Anand Niketan, but let's just go to Barota first, because this is the main thing. Now, just
pause it. Just turn to page 270. We must also deal with their case simultaneously.
Correct.
But now land, since you have covered, just turn to page 270.
Correct.
270, 218, which they showed to us. Because some emphasis was laid on paragraph 3 and 4, I just want to put it to you so that we have your paragraph 3 only.
Yes.
270.
That about 10 years back sold away the co-parcenary property, para 3. Yes. That is land measuring 30 acres at Bhaktao and joint family house which formed the nucleus of joint family by act of good management, and out of the said sale consideration, defendant purchased house number C38 situated at Anand Niketan and constructed a house. This is a pleading made by Mr. Sanjeev Singh and Mr. Rajiv Singh, whom you are representing. Correct. This is against their father in a suit for partition.
Correct.
So they are not parties here. they are not parties here, and assuming this happened.
Sanjeev Singh is your client.
Yes.
Rajiv Singh,
No, their clients are not party in this litigation.
Correct. But
their
admission on your part, this is.
But first, my point is, in this pleading, I have not said so. Second, assuming this is a factual position, it makes no difference to the case in hand. The property is purchased by the grandfather in his own name in 1968. It is transferred by a registered transfer document, and MCD issues it in my name in 1970. From 70 to today, there is no challenge to those documents. I have separately pleaded that in my in the subsequent points. I have separately. Here, for point C, my only point is this Bhaktao land does not exist. That's the only point today that I am making. Now, so that leads us now to two more properties which we have to deal with: the land at Baroda and the house at Anandikhet.
Point is slightly little nuanced. If you admit that you have sold some property and that forms the nucleus for the HUF, then it will stand on a different footing.
Here is the
crucial your reliance on the lease deed in the grandfather's name, and then subsequent transfer in your name will not then cut much of ice.
No.
Normally speaking, what you are saying is correct.
No, here is the
only because of this pleading there is a problem.
No, here there is a point. Whether there was an HUF or not, it will have to be pleaded in the plain. That is not pleaded. When did the HUF come into existence? The father's HUF. When did the HUF come into existence? When was the property thrown into the common hodgepodge? Was it if after the Succession Act comes into force, that pleading has to be made? There is no such pleading anywhere in the petition, and your lordships have ruled in more than one judgment that unless the facts are pleaded in the plain, there is no presumption of an HUF.
But look at the expression used at Pune 18 top.
Yes.
That is what is creating a bit of a concern. We want to put it to you so that you deal with it.
Correct.
Just see at the top, which formed the nucleus of the joint Hindu family.
Yes, here the joint Hindu family is Anup Singh's family.
Okay.
Here
when did your grandfather pass away?
My grandfather passed away.
That is General Butt Singh.
In 1988. He passed away in 1988.
And this suit is filed in 84.
Yes.
So during his life.
Correct. But he's not a part. But in fact, there is no joint family. This land which was at Bhaktao was given to the son. That is their pleading. I'll just show it.
Yes. What is that?
I will show it in the initial litigation. Now, if your lordship wants to see it, you just see the first suit which is filed, where this fact is mentioned. Even during the grandfather's time, this land was given to my father. Just see the first suit of 1972. Just come to page 152 straight away. What is that? That is the first suit of 72. And just see that. What is the pleading there in that suit?
So he doesn't know anything from
Alright. So just kindly have, and I am not the plaintiff. Somebody has to just see page 154. The plaintiff, and now in this suit, your lordship will see the plaintiffs are who? Sanjeev Singh, Rajiv Singh, sons of Anup Singh, and the two sisters. Now kindly see the suit at page 154. The plaintiffs and defendant schedule are as under: agriculture land measuring so and so, that is given. This is the land. Come to page 156. Gair Mumkin, situated in Baroda. So para 2 of the plain contains the details of the Baroda land. A Sonipat, according to Jamabandi for the year 66-67, is owned by the defendant and plaintiff number 1 due to ancestral property and comes in equal share, on which the plaintiff and defendant number 1 are having possession on their share of the set separately as owner under the following manners, and parties are having no concern with the petition of another. So para 2 says the plaintiffs and defendant number 1 are owners of the Baroda land. This suit will partition or divide the Baroda land between the plaintiffs and the grandfather. The father, Anup Singh, is out of this division. Why? Because of para 3. The land situated in Bhaktao, Tehsil Sonipat, was the property of the parties and defendant number 2 is having possession on it, that's the father. The same comes under the share of defendant number 2 in mutual partition. This is the suit they are relying on. And the defendant number 2 is absolute owner and possession of the entire land situated at Bhaktaun. So therefore, when this decree comes to be passed, the father gets nothing from Baroda. Because in as per pleadings in para 3, in the partition which happened, the father got Bhaktaun completely. And that is why the house comes to the father. Even if it is assumed it was so. But let me go a little further because I want to read this a little more because this is very crucial. So what happens in the first suit? The first suit decrees Baroda is partitioned between the 2 grandsons, the 2 daughters and the father. But the son gets nothing because Bhaktaun comes to him. That decree is passed. This decree is then made subject matter of the second suit. In the second suit, they concede the daughters that we have nothing to do with Baroda. It entirely belongs to the father. To that extent, the decree is modified. So, qua that part at Bhaktaun, that decree is complete and final. And therefore, in 68, when Anand Niketan is purchased by the father, it is given to the son. In 70, they have no right on it. And not today, by reading some document, suit here, suit there, and say 1 plus 2, 1 plus 1 plus 1 is equal to 4. You have to plead all this in the plain. You have to make out a case. What is you are agreeing in your suit that there was a partition and Bhaktaun went to the son, and then when was the common hodgepodge again made?
Mr. Patwale, the second suit says that the first decree is a nullity.
Now let us see the second suit also.
So the first decree becomes a nullity.
Let us see the second suit, not on impression. Just see the second suit. Yes. Now kindly see. Let's finish reading the first suit now. So para 3 says Bhaktaun. Just come back to page 156.
Yes, sir.
Para 3 says the land situated in Bhaktaun, the Tehsil Soni, I just read it, was the property of defendant number 2. Now see the next page. That due to mutual partition, plaintiffs and defendant number 1 are owners and possessors as under. So it's not defendant number 2. The Baroda land is now being divided between the plaintiffs and defendant number 1. Defendant number 2 is out of Baroda because of para 3. The plaintiffs and defendant number 1 are owners in possession, possessors as under, and of no concern of one owner to the shares of another. And let me tell you, Lordship, my Lord, in their written submissions before the High Court, they have given up this Baroda land in writing by saying there is a will, we will have to challenge the will separately. Single judge says, go and file a suit in Haryana. We are okay with that. I will read that written submission to your Lordships just now, after I finish this. And here it is being argued as if we are in a writ petition and we are dealing with the original pleading, original argument is being made before a single judge. There are two. You have filed documents. You are bound by those documents. Anyway, but I'm overlapping 2 points. I'm coming to para 6. So, my Lord, due to mutual partition, plaintiff and defendant number 1 are owners and possessions, and no concern of one owner to another. Details of the plaintiff and defendant are as under. Then para 4, they are given. First, Sanjeev's share is given 157. Lower half of 157, Rajiv, the 2 sons share. 158, Shrimati Saroj Salkan's share is there. Then 159, the grandfather's share is there. Both Singh. Then para 6. Please read para 6. Defendant 2 has been made party in the case due to the necessity by which defendant number 2 will be responsible and bind with the said partition in case of passing of the decree. 1 and 2 are minor, etc., etc. And then this is the suit, and the suit says, ultimately the prayer is, at page 165, prayer actually is from 162 onwards, that Baroda should be divided between the plaintiffs and defendant number 1. And the decree is at page 173, the type copy. 173 type problem.
That is not making any sense. We'll have to read 168.
173, sorry, madam. I'm sorry, 173. Sorry. Please come to one.
I'm just saying 173 is a bad type copy. It will not make
the brief facts of the suit are
because the last sentence is plaintiff defendant has a right to interest.
Has no. That's the only error is A should be read as no. I have actually corrected it in my copy. The word A should be read as no. Everything else is right, but anyway, I can read it from the. But your lordship may take it. I've read it. Everything else is right. Only in the last line, the defendant has A. Just write it down and substitute it with the word no. Now let me read it. The brief facts of the present suit for declaration are that plaintiffs and some of defendant number 2 and defendant 3 and 4 are daughters of defendant number 1. Defendant number 2 is son of defendant number 1.
Plaintiff number 1 and 2 are sons of defendant number 2, and defendant number 3 and 4 are the daughters of defendant number 1.
Correct.
Defendant number 2 is the son.
All right, I'll read it from there.
There's a lot of mistakes.
All right. Sorry. The my lord, this is
168 and 170.
The brief facts of the present suit for declaration are that plaintiffs 1 and 2 are sons of defendant number 2. Defendant 3 and 4 are daughters of defendant number 1. Defendant number 2 is son of defendant number 1. The land detailed in para 2 of the plaint was owned by defendant number 1. It was ancestral in his hand. As such, plaintiff 1 to 4 had share in the same. In the year 1971, it was partitioned between plaintiff 1 to 4 and defendant 1 in the manner as detailed in para 4 of the plaint. Plaintiff 1 got the land detailed in subpara K. Plaintiff 2 got land detailed in subpara KHA. Plaintiff 3 got the land detailed in para so-and-so. Plaintiff 4 got land detailed in subpara so-and-so. The remaining land remained with defendant number 1. Defendant number 2 got the land situated in village Bhaktaon. The parties are in possession of the land, which came to their share since then as owners. The land detailed in para 5 of the plaint was kept as joint as defendant started claiming title. Present suit for declaration was filed. Plaintiff 1 appeared through Shri SP Jain, Advocate Sonipat, and filed a written statement. Defendant appeared in person, also filed a written statement. Suit of the plaintiff is liable to be decreed. For the reasons I pass a decree. What is the decree now, my lord? Declaring plaintiffs 1 to 4 to be owners in possession of land detailed against their name in para 4 of the plaint. Defendant number 2 has no right, title, or interest in the same.
Defendant has no.
Defendant has no. Defendant has no. It should be defendant number. Oh yeah, defendant has no right. Oh, defendant has no right in the same. So the decree was confined to the Baroda property. And incidentally, my lord, if it is to be accepted that Bhaktaon had been sold, then on the day this decree had passed, Bhaktaon was already sold because that house was bought in 68. In 1970, conveyance in favor of the son was there by the MCT. Now see the second suit, what happens? But I can go on, but it will take a little.
But let's finish the second suit because those are.
All right. I can go on. Then
the second suit.
Give me a. Your lordship can give me some time during lunchtime also.
It's never good to argue over a hungry judge.
All right, then on a Friday at 3, I mean, let us be comfortable. Let me not be.
Just finish the second suit.
Yes.
And then you put it up.
I do understand that. In fact, I can also just do it in a huff, but not. There is no point.
No, we give you at 2 o'clock.
Yes.
Post lunch.
Yes. Now see the second suit. Second suit is at page 179.
First, we will keep it at 2 o'clock.
All right. then let me do 2, 3, 4 together because I want to link all 4 of them.
No problem.
I want to link all 4.
Our only request, Mr. Patwalia.
Oh, Lord, I will finish with as quickly as possible. Your Lordship will not have to tell me.
Just, you initially said 20 minutes. They said 20 minutes, 3 minutes. We are not curtailing you, but in terms of time. Only thing is don't repeat. So first we will keep it at 2 o'clock and we'll request with folded hands, all of you, we'll conclude the proceedings then.
Well, we have nothing to argue on our side. We won't take it.
Then
Then
by 3:30, 3 o'clock.
No, I'll take 10 minutes, 5 minutes. 10 minutes.
Redo your submission.
All right,
That's entirely.
all.
Yeah, redo so that.
I will make
additional
one
and
copy.
this may not.
All right.
Lord, I may again appeal, just a second.
Going to supplement what were learned senior friends.
That's okay. After he argues, probably
Purchaser.
nothing may remain. Yes.
5 minutes.
Lord, I must say again, Lord, under the, if it is HUF, it is not, let us assume it is 33, Lord, person shares, two sisters and brother. Now, Lord, we are giving up instead of that 66.5%. I am saying we will take between 2 of us only 40%. So we are giving up additional 26% share in his favor.
That you did the last time.
I know, but I am appealing.
This is not a writ
I am appealing to Mr. Patwalia's heart. I am appealing to Mr.
They
Patwalia's
have
heart.
got.
I have always
I don't
known him
want to
to be a
respond
very
this
conscionable counselor.
This kind of submission. Yes.
Anyhow,
yes.
Heard further. List on 1st of April.
First April.
1st April at 2 p.m. Registry to list the matter as per this.
Grateful.
Courtmaster. The bell. They won't come. They will not imprison your lordships. Unless they open your lordships, can't go.
Yeah, it's a pleasure.
May I mention item number, the next item?
There's another item.
That will not take much time, I don't.
Husband लड़की की डेथ हुई थी 25 लाख दिया था बच्चे के
आगे की
स्पेशल डिसेबिलिटी
उसे same day.
3 o'clock at
No, 2 o'clock.
First at 3 o'clock.
3 o'clock. Your matter at 3 o'clock.
So Mr. Dave wants to.
See it.